Adjournments. List number 1, page number 14, serial number 42.
Serial number 13 ನೀವು
ಅದ್ ಕರ್ದಿಲ್ವಲ್ಲ 42. Yes.
Page number 15.
My lord, serial number 40.
3 to 47.
Not been called. Whatever is been called, ಅದು ಮಾತ್ರ ಹೇಳಿ.
43 to 47. Page number 16, serial number 48 to 55.
Serial number 52, my lords.
Yes.
I appeal for the petitioner. Wait for short accommodation in this case.
Have you informed the respondent?
Respondent, I have informed.
52 at the request of counsel for the petitioner. Relist on 2nd August.
Interim order has been.
Interim order earlier granted is extended till next date.
Page number 17, serial number 56 to 62.
Serial number
57 my lord. 57.
Hmm.
For petitioner counsel my lord. Next week.
Respondent inform ಮಾಡಿದೀರಾ?
ಅಲ್ಲ, state it in court. State my lord respondent.
State ಅಲ್ಲಪ್ಪ SN Mahesh for R4 ಅಂತಿದ್ದಾರೆ.
57 my lord.
57.
Appear for petitioner counsel my lord.
ಇಲ್ಲ
Not
ಬಿಡಿ.
keeping well.
Not if you are not informed. Next.
Serial number 60, Your Honor.
Hmm.
Petitioner,
Yes.
mainly next week.
At the request of counsel for the petitioner, relist on 1st August, 2nd August.
My lord, name submission.
Yes. Yes.
Serial number 40, my lord, final hearing.
Huh?
I appear for the
40. ನೀವು ರೆಸ್ಪಾಂಡೆಂಟ್ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದೀರಾ ಪೆಟಿಷನರ್ಗೆ?
Inform.
My lord, I send the interim order until further.
40 at the request of counsel for respond number 4 to 6 and 8 to 11. Relist on 2nd August, interim order earlier granted is extended till next week.
My lord, interim order may be extended and.
Extended, madam.
For the order.
No, don't ask those kind of things. Yes.
Cast list to, cast list to. 230 matter, cast list to.
Michael Mathad,
230 matter, cast list to, my lord.
cause list 2.
Serial number 3. Senior.
2, serial number 3. Admission, yes, RSA.
RSA.
ಏನ್
Serial-
admission ಇವತ್ತಾಕೆ? ಇವತ್ತಾ?
Press time, my lord. Senior is out of session.
Responding inform ಮಾಡಿದೀರಾ?
Inform ಮಾಡಿದ್ದೀನಿ, my lord.
3 at the request of counsel for the appellant, relist on 29th August.
Serial number 39 you final hearing. Senior ಗೆ ಹುಷಾರಿಲ್ಲ ಸುಮ್ಮನೆ. Week ಒಂದು ಶಾರ್ಟ್ ಅಕಾಮಡೇಷನ್.
Respondent inform ಮಾಡಿದೀರಾ?
ಮಾಡಿದ್ವಿ.
At the request of counsel for the petitioner, relist on 2nd August.
ಮಸ್ತ್.
My lord, in the same list, 41, my lord, I am for the respondent. I inform the Balkrishna Sastri sir for petitioner.
41.
I am for the respondent, my lord. And
At the
short
request of
accommodation.
counsel for respond number 3, relist on 2nd August.
List number 1, order serial number 1, Pradeep Nair.
My lord, I am for the petitioner. Amended petition has been filed.
Hmm.
That amendment not carried. It
Carry it
runs about 3 to 4 pages. Or 2 days.
Dot.
2 days time maybe. To it.
Counsel for the petitioner seeks bond is granted 3 days time, a week's time
Please.
to carry out the amendment. If the amendment is not carried out by 26th, the petition would be liable to be dismissed for non-prosecution. Relist on 2nd August.
Please.
Serial number 2,
Records ಬಂದಿದ್ಯಾ madam?
Lord, yes, ma'am.
Secure records.
ಬಂದಿದ್ಯಾ?
Yes, ma'am.
Learned SCGP submit that the records have been secured. Counsel for the petitioner is permitted to take inspection of the said records by the next date.
Serial number 2, P Nataraju.
Appearing for the petitioner, sir.
Yes.
Earlier ಆಗಿ ಸ್ಟೆಪ್ಸ್ ತಗೊಂಡಿದ್ದು ಮತ್ತೆ ರಿಟರ್ನ್ ಆಗಿದೆ ಸರ್. ಫ್ರೆಶ್ ಅಡ್ರೆಸ್ ತಗೋತೀವಿ. ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್
P1A is dead. P1A ಗೆ ಏನ್ ಮಾಡ್ತೀರಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ, P1A ಗೆ ಮೆಮೋ ಫೈಲ್ ಮಾಡಿದ್ವಿ.
ಏನಂತ?
ಅವ್ರ ಲೀಗಲ್ ಏರ್ಸ್ ಇಲ್ಲ ಅಂತ ಹೇಳಿ ಫೈಲ್ ಮಾಡಿದ್ವಿ.
ಈಗ ಲೇರ್ಸ್ ಇಲ್ವಾ?
ಫೈಲ್ ಮಾಡಿದ್ದೀನಿ ಸರ್.
ಈಸ್ ಎಕ್ಸ್ಪೈರ್ಡ್ ಅಂತ ಅಷ್ಟೇ ಮೆಮೋ ಫೈಲ್ ಮಾಡಿರೋದು. ಅವ್ರ ಲೀಗಲ್ ಏರ್ಸ್ ಯಾರು?
ಸುಮ್ಮನೆ
P1A Murgaya.
P1A ಶಿವರಾಮಯ್ಯ.
Shivramaya Urf Mugaya.
ಹೌದು.
Our legal heirs ilva?
ಇಲ್ಲ ಅಂತ ಹೇಳಿದ್ದಾರೆ ಸ್ವಾಮಿ, ಅದನ್ನು ಒಂದ್ಸಲ ವೆರಿಫೈ ಮಾಡ್ತೇವೆ, ಯಾಕಂದ್ರೆ ಇಲ್ಲ ಅಂತ ಹೇಳಿದ್ದಾರೆ, ವೆರಿಫೈ ಮಾಡ್ತೇವೆ.
Counsel for the petitioner seeks for a short accommodation to verify if the any
P1A.
legal heirs of petition number 1A,
ಹೌದು.
and if there are, to file necessary application to bring the legal representatives, bring his legal representatives on record.
ಒಬ್ಳೆ
ಆಮೇಲೆ R4A,
R4A ಗೆ ನೋಟಿಸ್ ಜಾರಿ ಆಗಿದೆ.
counsel for the petitioner seeks fund is granted a week's time to make payment of process fee in respect of respondent number 4A. If needful is done, registry is directed to issue notice to respondent number 4A returnable by 26 September, 27 September.
ಒಬ್ಳೆ
Serial number 3.
Lord, in respect of petition number 8 and 9, my lord, filed the LR's application and that has been allowed. I have to carry the amendment, my lord, I will do it in a day, my lord.
Yes.
Insofar as the IA for bringing the LRs of P1, my lord, I need 2 days' time, my lord, to verify. Because objection has been raised regarding the non-submission, non-filing of the genealogical tree. Lord, 2 days' time, my lord, it may be.
There is no objection.
Yes, my lord, they have filed objection.
ಅಂತಂದ್ರೆ P1 LRs ಅಂತ ಹೇಳ್ತಾರೆ.
ಹಾ.
ನಾನು postal ಸರ.
You have filed objection.
I filed objection.
ಹಾ.
He is not person available. I have sent it by registered court, cover and acknowledgement,
Huh.
returned with answer. And also, I will verify that he is not the LRs of the petitioner.
So you are
That's why I filed
objecting.
objection.
Lord, I'll file a better affidavit, my lord, 3 days' time, my lord, 24th it may be called, my lord, I'll rectify all the office
The
objections.
petitioner seeks for a short accommodation to carry out the amendments in respect of the arraying of the legal heirs of petition number 8 and 9. He seeks for and is granted a week's time to file rejoinder to the objections filed to IA 7, 8 and 9 of 2023.
Please,
Rejoinder, if any, to be filed on or before 26, relist on 2nd August.
please.
Serial number 4. SV Prakash. You have received records.
Yes.
I'm ready.
Ready?
Ready.
Mr. Ananda? Paso.
Serial number 5.
Spot number 3, 4 and 6.
My lord, I appear for the petitioner. The petitioner has filed, the respondent has filed a IA for vacating stay. My humble request is that the matter may be posted for final hearing and could be disposed of.
It's posted today only for 5
Yes.
years. Really?
Next date only, then I will do that.
My lord, it's a 2016.
Consideration of IA 1 of 19 would amount to consideration of the entire matter on merits as such. IA 1 of 19 will be taken up along with the final hearing.
Please, ma'am.
Relist on 2nd August for final
Please, ma'am.
hearing. It's made
I
clear
will do that.
that no further.
Because I am
adjournment-
relying upon your lordship's judgment.
ಹೌದು
Render.
ಗೊತ್ತಿಲ್ಲ. Argument
I
ಮಾಡೋದು
am-
ಮಾಡಿ.
ಅಲ್ಲ ಅದರಲ್ಲಿ
It is made
But-
clear that no further adjournment would be granted. If arguments are not advanced by the petitioner, the petition would be liable to be dismissed for non-prosecution. Shri Pundrika Ishwar Bhatt has entered appearance for the petitioner. Registry is direct, delete the name of Shri K. Giridhar as that appearing for the petitioner. He is discharged from. the
Great.
court.
Serial number 6. Prasanna
Seven in
Kumar.
this case.
If I
Condition
appear for
orders
the
then-
Petitioner, I am unable to contact the petitioner in this matter, my lord. I have to issue, I have to provide. PF to-
Retirement. The counsel for the petitioner submit that she is unable to contact the petitioner and secure instructions. She seeks for 4 weeks' time to issue necessary retirement notice and file the same before this court. Relist on 13th September.
Yes. There is interim order in this.
Interim order earlier granted is extended.
Then August August ತಿಂಗಳು ಡೇಟ್ ಕೊಡಿ ಮೇಡಮ್ ಲಾಂಗ್ ಡೇಟ್ ಹೋಗ್ತಿದೆ.
August
ಕಂಡೀಷನ್ ಆರ್ಡರ್ಸ್
13th.
ಇದೆ.
Yes, sir. ಎಲ್ಲ ಇವ್ರ ನೋಟಿಸ್ ಹೋಗಿ ಬರ್ಬೇಕಲ್ಲ,
ಪ್ಲೀಸ್ ಮೇಡಮ್.
4 ವಾರ ಅದಕ್ಕೆ ಆಗತ್ತೆ. ಸೊ ಆಗಸ್ಟ್ ಅಲ್ಲಿ ಬರಲ್ಲ, ಸೆಪ್ಟೆಂಬರ್. ಮತ್ತೆ ಸುಮ್ನೆ ಏನಕ್ಕೆ ಅನ್ನೆಸರಿ ಲಿಸ್ಟ್ ಬೇಡ.
ಡೇಟ್
13th September.
ಮಚ್ಚ.
Serial number 7. R. Shashidhara.
Yes, ready, ma'am. I'll file it in the counter.
Yes, ready.
ಇಲ್ಲ ಕೊಡಿ.
Please.
Counsel for the petitioner has filed application to challenge the constitutional validity of amendment to section 5C of the Karnataka Scheduled Caste and Scheduled Tribes Act 1978. being of the considered opinion that the said amendment is necessary to properly and effectively decide the list between the parties. Said amendment is allowed, counsel for the petitioner to carry out necessary amendment and file amended petition. Ready, yeah? Released on 26th July,
Second July.
26th.
Second July. My case.
We are finishing the matter. ಇವತ್ತು arguments ಇದೆ. ಇದು ಬರೀ ಅವ್ರದ್ದು ಅವ್ರೇನು ಹೇಳಂಗಿಲ್ಲ, ಎಲ್ಲಾರ್ದು ಆರ್ಗೋಗಿರತ್ತೆ. ಸುಮ್ನೆ ಅಲ್ಲೋ ಅಂತಾರೆ ಅಷ್ಟೇ ಅವ್ರು.
Okay, sir.
ನೀವೇನ್ ಹೇಳ್ತೀರಾ ನೀವೇ. ಇವತ್ತೇ ಹೇಳ್ಬೋದು, ಇಲ್ಲ ಅವತ್ತೇ ಹೇಳ್ಬೋದು.
Serial number 8.
Your Lordship, I appear for petitioner
Yes.
because last occasion, the Lord, there was an office objection since I have not filed the application to set aside the abatement. Today I filed, my Lord. I filed it in the counter today because.
File it or
Filed. I have
Filed.
filed it. Yes, my Lord. It's
pass
filed.
over. That's.
Yes.
Yes, please.
Serial number 9.
Hearing for petitioner,
Hmm.
each time allowed filed the application for respondent number 4 is died.
That counsel for the petitioner seeks for and is granted 10 days time to file necessary application to bring the legal representative of deceased respondent number 4 on record, released on 2nd August.
Please.
Serial number 10. DM Siddhappa.
Siddhappa. Paso.
11.
I appeal for respondent number 5 in this case, my lords.
Hmm.
Because they had to file an application for bringing alerts on record.
Compliance of office objection raised on IA1. Anything?
I have filed, I have already filed IA for bringing alerts for R6 in this matter.
What is the objection on this, Mr. Kodgi?
Provision of law.
Oh, that I am very familiar.
Regarding set aside abatement is not put.
Set aside abatement Akila. Counsel for the petitioner
He
seeks
has
for and
been
is granted
put to
10
the
days time
matter.
to comply with the office objections released on 2nd August.
One more submission, my lords, the writ petition which is served on me, there are so many pages that are missing, my lords. They
Missing?
were Missing.
Yeah,
They may
Mr.
put
Kodgi, you are given a,
order itself is not available, my lords.
give a proper set. Counsel for the petitioner is directed to furnish a full and complete set of the petition along with all annexures on the counsel for respondent number 5 by next date.
Much obliged, my lords.
Serial number 12. Gautam Mayor.
I seek for 2 days time to file the application, my lords.
For the respondent number 4, my lord.
That's on Monday it will be filed.
How long do you take to file one application?
Already they have taken sufficient time.
My lords, the
If you are not
application will be
challenging
filed.
it, your petition is not maintained, we'll dismiss it.
My lords, let there be a, my lords, on Monday, my lords, it will be filed.
Pass over, file it today.
My lords, on Monday, my lords, I need.
My lords, file it now. Pass over.
13. Sri Harsha Eke.
I appeal for
Yeah,
petitioner, my lord.
Nine
Kindly,
objections.
kindly 1 week time, my lord.
Counsel for the petitioner seeks for and is granted 10 days time to comply with office objection. Office objections to be complied with on or before 30th July. If not complied with, the petition would be liable to dismiss to non-prosecution, released on 2nd August.
14. Prashant MM.
For the petitioner, dates of, take the
Third
steps
records.
against 4 and 5.
I secured the records.
Then SCGP submit that the
My lord,
records have been
kindly
secured.
send the interim order.
Process fee ಕೊಟ್ಟು ಆಮೇಲೆ ಹೇಳಿ. Pass over, process fee ಕೊಡಿ. ಇವತ್ತೇ
Today,
ಕೊಡ್ತೀರಾ?
ಇವತ್ತೇ ಕೊಡ್ತೀನಿ sir.
The records have been secured. And counsel for the petitioner and respondent number 3 are permitted to take inspection of the same. Counsel for the petitioner submit that the process fee in respect of respondent number 4 and 5 would be paid during the course of the day. If needful is done, registry is directed to issue notice to respondent number 4 and 5 returnable by 13th September. If the process fee is not paid,
ಇನ್ನು
interim order earlier granted is extended till next date. If process fee is not paid by end of day today, the interim order will stand automatically vacated.
ಮತ್ತೆ
Records.
15.
Records ಬಂದಿದೆ ನೋಡೋದು.
ಗೋಪಾಲ Krishnamurthy.
Paying for petitioner, my lord.
Yes.
IA is ready, my lord.
Give us.
Furnish it in counter.
Kodi. IA is ready.
Yes, my lord. I will furnish it in counter. I have to stitch, my lord.
Pass over. You give it to Sierra.
Okay.
Serial number 16. P. Narayanappa.
1 week's time is finally granted to the petitioner to make payment of necessary process fee. If the process fee is not paid by 30th, the petition would be liable to be dismissed for non-prosecution, released on 2nd August.
17.
Lots of-
Abhinav S.
Lords, I've done the needful this morning, my lords. I apologize.
For the petitioner, submit that the deficit process fee has been paid, registry to verify. If
My lord,
not-
if I submit, respondent number 4 to 6, my lords, I filed my wakalat in the office on 6th of July.
4 to 6.
Please, my lord.
Lords, they had filed a caveat petition, my lord. We had.
5, 6 is 5 to 8
Five-
service ಆಗ್ಬೇಕು.
Yes.
7 and 8 service ಆಗ್ಬೇಕು son. 4 to 6 I filed wakalat.
ಆಯ್ತು 7 and 8 ಗೂ ನೀವು ಹಾಕ್ತೀರಾ ಅಂತ.
ಇಲ್ಲ, I don't have instructions, my lord.
Don't submit that is going to appear, is filed wakala, you filed wakala.
I filed wakalat, my lord.
For respond number 4 to 6, registry is directed to print his name as such and delete the name of Shri Ravikiran C as that appearing for caveat respond number 4. Counsel for the petitioner submit that he has made payment of the deficit process fee in respect of the remaining unserved respond
Please.
number 7 and 8.
Please.
Registry to verify if needful has been done, issue notice to respond number 7 and 8 written by 13th September. If needful is not been done, relist on 26th for dismissal.
May I submit this, my lord?
The
I
interim
filed
order.
I filed my objections along with an application for vacating the interim order.
Hmm.
No objections have been filed yet as of now. My request for a shorter date in the matter, my lord. I am the original legal error, the original grantee, my lord.
7 and
the
8, who are
application-
7 and 8?
7 and shorter date may kindly be.
Who are 7 and 8?
7 and 8 are part of the family, my lord, but they are
Children.
not with us insofar as instructing me, my lord.
If you are going to appear for them, we'll have it next week. No problem about it. If you're not going to appear, register post hogbharat 4 weeks agatte. So we'll have it only in September.
May I then request your lordship to have it next week so that I'll obtain the instructions of my clients and see if the other family members also could be.
We'll not do that. You get instruction, we'll pass over.
Please, my lord.
We won't list only for that.
I understand. Kindly pass over, my lord.
We have seen RSAL and so
I
nam
understand.
ಮೊನ್ನೆ 3 ದಿನ I was not well because of dust.
I understand. I understand.
People are working in inhuman atmosphere. And each listing contributes to their
I know,
problem.
I
So
understand.
we
I
don't
understand.
want to list unnecessarily.
I request your lordship to pass over. I'll obtain
We'll pass
instructions.
over, you let us know.
Please, my lord.
Pass.
Obliged. Obliged, my lord.
Serial number 18.
For the petitioner, my lords, I filed the application on Monday, my lords, in
Idea.
the second matter.
First matter,
First matter, I'm only challenging the rejection of interim order. So in that matter, I have not challenged the
current counsel
constitution.
for the petitioner submit that she does not wish to challenge the constitutional validity of the amendment to section 5C in the above matter. 18.1 ಬಂದಿದ್ಯಾ?
I have filed it on 15.
18.1 5C allowed counsel for the petitioner to carry out amendment, file amended petition based on 26th.
Much obliged.
Serial number 19. Sarvana S.
For the petitioner, my lord. Kindly pray for on short accommodation, my lord, to take a necessary application. my lord.
Counsel for the petitioner seeks deceased R5 and 10.
R5 and 10.
Seeks for and is granted 3 weeks time to file necessary application to bring the legal representative deceased respond number 5 and 10 on record.
Kindly
List on 23rd August.
My lord, kindly intermediate.
Interim order earlier granted is extended till next day.
Serial number 20. Harsha R.
Appealing for petitioner, my lord, kindly give 2 weeks time. I say advocate on record is not in station.
Who is appearing for the caveator? Mr. Adi Narayana. Learned counsel for the petitioner seeks for and is granted 2 weeks time. to
Yeah, 2 weeks.
comply with the office objection. Relist on 2nd August.
Much obliged, my lord.
Serial number 21.
Petitioner,
Yes.
annexer M ಒಂದು typed copy ಮಾತ್ರ ಕೇಳಿದ್ದಾರೆ.
Good.
So
In council submission in. Eligible copy. Then remove this copy, remove annexure M.
on record counsel in another court. So
Your
either pass or
submission is in annexure M, petitioner not party, there is only reference to
no.
that order.
typed copy.
Hence type copy not necessary, and artha adu.
Kindly pass.
What do you
over.
mean?
The record counsel will come in.
Pass over.
Your lordship, sorry to interrupt. I forgot, interim order in serial number 18 may kindly be extended. my
18
lords.
interim order extended till next date.
Much obliged, my lords.
Hearing on IA, serial number 22.
I appear for the petitioner sought for amendment, my lord.
ಏನ್ ಅಮೆಂಡ್ಮೆಂಟ್?
Procedural, ಅದೇ ಸ್ಟೇಟ್ ಇದಾಗಿರೋ
Purchaser melon.
ಪರ್ಚೇಜರ್.
5C
challenge.
5C challenge, so and so ಅದಾಗ್ಲೇ ಹೇಳಿದಲ್ಲ. IA 7 allowed. Counsel for the petitioner is granted a week's time to file necessary, carry out necessary amendment, file amended petition, released on 26th.
Interim order may be.
Interim order earlier granted is extended till next date. 22.1, same order, IA 1 of 24 is allowed.
Serial number 23.
Appearing for petitioner in this case, my lord.
Hmm.
My lords, I have filed application to implement the state as a party, as I am challenging the amendment, my lord.
Impleading the state.
My lord, appearing for respondent number 1, praise time to file objection for amended writ petition, my lord.
Yes. IA 2 of 2024 has been filed to bring on record the state as a party, since there is a challenge made to the amendment to section 5C. Accepting the reasons stated in support of IA 2 of 24, the said application is allowed, since the state would be a proper and necessary party to consider the relief sought for. Counsel for the petitioner to carry out necessary amendment, file amended cause title. That counsel for the respondent seeks bond is granted.
1 week time.
A week's time to file objections to the amended main petition ಹಾಕಿದ್ದೀರಾ?
Main petition ಹಾಕಿದ್ದೀನಿ.
To the amended petition, released on 26th.
Much obliged.
24.
My lordship, I'm advocate for petitioner in this case, my lordship.
Yes.
Last date of hearing on 31/5, this honorable court has order for notice on IA number 1 to 6, my lordship.
Hmm.
Process fee has to pay within 5/6/24, my lordship.
When did you pay?
I paid on 10th July, my lordship. The reason is this, my mother is seriously ill. She suffered from cancer. Later she passed away. That's why I'm unable to come and do.
Yeah, who passed away?
My mother, my lordship.
Sorry. Our condolences. Counsel for the petitioner has filed IA 1 of 24 for seeking for condemnation delay of 9 days. And IA 2 of 24 for recalling the order dated 31/5/24. Accepting the reasons stated in support of both the applications, the said applications are allowed. The order at 3, the order at para 3, and the para 3 of the order dated 31/5/2024 stands recalled. The petition is restored to file. The process fee paid, though belatedly, is accepted. Issue notice on IA 1 to 6 of 2023, returnable by 27th September.
Much obliged.
Serial number 25. Sanjay Krishna and connected matters.
Appear for the petitioner, your honor.
ಏನ್ರಿ ಇದು ಇಷ್ಟೊಂದಿದೆ? IA 1 of 23 for dispensation with production of silk. What is annexure A? You know all these things, what, you've seen all these things or you've not seen everything?
I've seen my one.
Then
Only
make your
one,
submission.
only the first one is mine. Rest all is filed by the
So first one, you
respondent.
make your submission.
What
is this item number 1?
Item number 1 is certified copy of the order, common order passed by the ACU.
So why do you want a dispensation?
Because the certificate copy was not obtained by them.
You filed this petition in 23, now we are in 24. Could not you get it till now?
Have applied.
So find out everything and make your submission.
My lords, with respect to one more thing.
You make all your submission at one go, not in pieces.
For me, respondent number 5 party in person. New Jersey ನಲ್ಲಿ ಇದ್ದಾರೆ, ಇದು ಪರ್ಮಿಷನ್ ಇಲ್ಲ ಅಂತ ಹೇಳಿ ಮಾಡಿದ್ದಾರೆ. ತಾವು ಇದು ಕೊಟ್ರೆ ಅವ್ರು ಅಲ್ಲಿಂದ VC hearing ತನಕ.
VCL ಬರ್ಲಿ.
ಇಲ್ಲ ಇಲ್ಲಿ ರಿಜಿಸ್ಟ್ರಾರ್ ಕಂಪ್ಯೂಟರ್ ಅಲ್ಲಿ ಮಾತಾಡ್ದೆ ನಾನು. ಸೊ ಅದೇನೋ ಈಗ ಸ್ಟಾಪ್ ಮಾಡಿದೀವಿ ಔಟ್ ಆಫ್ ಕಂಟ್ರಿ ಇಂದ ಅಂತ ಹೇಳ್ತಾರೆ.
Out of country in this.
No, sir, that respondent number 5 is not.
Form C not obtained. In a party in person committee ಹೋಗಿಲ್ಲ ನೀವು. Or first
ಕೇವೆಟ್ ಇದ್ರಲ್ಲಿ ಫಾರಂ A, B, C ಎಲ್ಲ ಫೈಲ್ ಮಾಡಿ.
ಯಾವ್ದ್ರಲ್ಲಿ?
ಇದರಲ್ಲಿ ಕೇವೆಟ್ ಫೈಲ್ ಮಾಡಿದ್ವಿ ನಾವು, ಕಾಮನ್ ಆರ್ಡರ್. ಇವರು 3 WP ಫೈಲ್ ಮಾಡ್ಕೊಂಡು ಬಂದಿದ್ದಾರೆ ಒಂದೇ ಆರ್ಡರ್.
ಇಲ್ಲಿ ನೋಡ್ರೆ ಫಾರ್ಮ್ ಸಿ ನಾಟ್ ಇಶ್ಯೂಡ್ ಅಂತಿದೆ, ನಾಟ್ ಒಬ್ಟೈನ್ಡ್ ಅಂತಿದೆ ಅಲ್ಲ.
ಸರಿ ಸ್ವಾಮಿ, ನಾನು ಅದು
ಅವ್ರ ಫಾರ್ಮ್ ಸಿ ಅವ್ರ ಕಮಿಟಿ ಮುಂದೆ ಹೋಗ್ಬೇಕು. Only after Form C, then we'll permit him. Otherwise, illa.
There is some urgency in this matter, Madam.
Yes, we are passing it over because there's each item has some 20 objections. We'll have to
My
clear
lords,
them.
with respect to the annexure A, in the certified copy is produced in other.
You ready for all items? Then
Yes,
don't
ma'am.
say, give me time. Find out, read it properly and make your submission.
I'm ready with all this. Only with that annexure A was not clarified, it was clarified.
You are taking the chance. Yes. What is this annexure A?
Annexure A is impugned order.
So why have you not produced it?
It has been produced in other writ petitions.
Which one?
In one. In 13239,
13239.
5.2, 25.2.
A 1 of 23 has been filed seeking for dispensation of production of certified copy of annexure A. Found that the said certified copy has been produced along with WP number 13239 of 2023. Hence, accepting the reasons, IA 1 of 23 is allowed. The production certified copy of annexure A is dispensed with. What is this rectification of memos filed by R6? Who is R6?
Notice, I am appearing for the, no. R6 is party.
Party in person.
No, R5 is party in person.
R6 also.
R6 is wife of
Wife of Notice R5.
R5.
Nobody has appeared for R.
So she has filed a memo stating that she is authorizing her husband to.
Learned AGA accepts notice for respond number 2 and 3. Registry is directed to print name as such. R6 in memo.
R6 copy not served.
Yenad memo adu.
It might be authorizing her husband to appear on behalf of her.
Might be, but we are passing orders. We can't pass orders and might be.
Memo for submission of special power of attorney.
Memo dated 15/4/2024 has been filed by respond number 6 stating that her husband, respond number 5, may be permitted to represent her. Respond number 5 is yet to obtain Form C in terms of the so-and-so rules. While the committee is considering the said representation, the committee is also directed to consider the request made by respond number 6 to permit respond number 5 to appear on her behalf. Then it is 6/3/24. In on memo. It's 3/24. Memo dated 6/3/2024 is also to a similar effect. The committee is directed to consider the said memo. 15/4/24. What is 15/4/24?
Adoption of objections. Could only be connected with you.
A memo dated 15/4/2024 has been filed by respond number 10, 11, and 12 to treat the objections filed in WP 13200 of 2023 as objections in the other matters. The said memo is accepted. The objections filed in 13200 of 2023 is taken as objection in the other writ petitions. On memo, ಯಾವ್ದು ಇದು? 15 ಸಿಗ್ತಾ ಇಲ್ಲ ಇಲ್ಲಿ. Item number 4 ಸಿಗ್ತಾ ಇಲ್ಲ ಇಲ್ಲಿ. Who is appearing for 10 to 12? Ishwara, why so many memos? Another memo dated 18/6/2024 has been filed by respondent number 10 to 10 to treat the objections filed in WP 13200 of 2023 as objection in the other writ petition. A memo filed to a similar effect on 15/4/2024 has been allowed. Hence, the memo dated 18/6/24 is also allowed. Memo dated 6/3/24. ಯಾವ್ದಿದು ನೋಡಿ, ಇನ್ನೊಂದು 6/3/24 ಕಾಣಿಸ್ತಾ ಇಲ್ಲ. Item number 4 and note 25.1. Same IA 1/23 is allowed. Same order as IA 1/23 in 13/200. Consideration of IA 1/24 would amount to consideration of the matter on merit, hence IA 1/24 will be taken up along with the merits of the matter. What is this item number 3 filed by R6? Item number 3 gets same order as in item number 3 of 13/200. Item number 4 same order as item number 2. Item number 5 is the same order as in item number 5. Objections are 5 and 6.
My lord, I am respondent number 5,
Yes.
and
You
I
are
am
yet to-
representing.
You are yet to obtain Form C. You will have to go approach the committee and get the permission.
My lord, I have obtained the permission from for 3 other cases, including current one which is running WA 267 257 of 2024.
Mr.
And
James, Mr.
yes,
James,
yes.
we are concerned with these 3 matters which are before us. You might have
Yes.
got permission in other matters. On similar rounds and reasons, they will give you permission in this, but you'll have to get permission in these 3 matters.
My lord, I'm seeking under Rule 10 a waiver for this. I'm the one who drafted the writ petition.
We are not the concerned authority to pass orders. There's a committee. Please approach the committee.
My lord, as a respondent, I was given the notice to say in person, you can appear in person or through a
Mr. James, the
representative.
manner in which you are arguing will make you disentitled to appear. If you're not able to understand the simple thing, then
I'm
you'll
abroad,
not
my
be able to
lord.
understand anything more.
Earlier, they didn't raise this objection, my lord.
Then we'll observe here that you are not competent to represent the matter. You want us to observe that?
No, my lord, I will seek I am abroad from that time onwards, my
So
lord.
please approach the committee. The committee will decide that. 7 memo dated 15/4/2024 is allowed. Memo dated 18/6/2024 is allowed. Objections of respondent number 5 to 6 are treated as objections filed by respondent number 16 to 18. Again, ಇದು ಇನ್ನೊಂದು 6/3/24 ನೋಡಿ ಅದು. R17 is still to be served.
My lords, they have already filed a memo,
Stating what?
like, in the very same petition, they filed a memo dated 6/3/24
Hmm.
stating that they may be represented by R5.
Yes, but Mr. Ishwara has appeared for some of them. We cannot file a memo for who are 16 to 18.
Narayan Swamy, M.N. Kusuma, B.N. Mohan Kumar.
They are not family members.
They're not family members, but
They cannot represent.
no, they have. I'm just bringing to a large notice that they have already got to know about the case, so it may be taken as served. Or else I'll first serve them the physical copy when they're present.
R17 has not been served.
I will take steps.
Counsel for the petitioner seeks for and is granted a week's time to make payment of necessary process fee in respect of respondent number 17. If needful is done, registry is directed to issue notice to respondent number 17, written by 20th September. 25.2, consideration of I1 of 24 would amount to consideration of the above merits on matter on merits, hence it will be taken up along with the merits of the matter at the time of final hearing. Memo furnishing the power of attorney is allowed. Process fee for R6. R6 is served. R6 has already been served, and the question of making payment of process fee in respect of R6 would not arise. Memo dated 15/4/24 is allowed. The objections filed in WP 13200 is treated as objection in all other matters. Memo dated 18/6/2024 is allowed. The objections filed by R5 and R6 is treated as objection filed by respondent number 10 to 12. Memo dated 6/3/2024 has been required and directed to be considered by the party in person committee. Shri A.J. James, party in person, is present before this court through VC. He is directed to approach the committee to obtain necessary Form C in all the matters. Relist on 20th.
Interim order granted earlier.
Interim order earlier granted is extended till next date.
This grow more food matter.
ಇದು grow more.
MF, please.
ಇನ್ನ ಎಲ್ಲ ಸರ್ವ್ ಆಗಿ ಬರ್ಬೇಕು.
26.
26.
Serial number 26.
R3 notice ಹೋಗಿದ್ಯಾ?
ಸರ್ವ್ ಆಗಿದೆ.
Only R3 ಏನ?
Please.
You appear for R3?
No, I appear for R4, my lords.
During the pendency of the above matter, respondent number 3 expired on
17/4/2002.
hence IA 1, 2 and 3 of 24 were filed on
18th April 2024.
18th April 24. Accepting the reasons stated in support of IA 1 of 24, delay of 187 days in filing the application is condoned subject to payment of cost of ₹1,000 to the Advocate Clerk's Benevolent Fund. By accepting the reasons stated in support of IA 2 of 24, the abatement in respect of respondent number 3 is set aside. By allowing 3 of 2024, the person named therein are brought on record as respondent number R3. A. Person named therein is what? IA 1, 2, 3 were filed. Notice having been issued. Respondent number 3A was served. No one has entered appearance. Hence, Amela. Relist on. In stage any day, though? B group. Relist on 23rd August. Records in Arubeka? ಇರ್ಲಿ ಅಲ್ಲ ಬೇಕಾ ಅಂತ ಸುಮ್ಮನೆ ತರ್ಸೋದು ಬೇಡ. ಇಶ್ಯೂ ಏನಾದ್ರು ಇದೆಯಾ?
Purchasers before this honorable purchasers.
SCG AGA is direct secure the records by then.
Please. Serial number 27.
My lord, I am appearing for petitioner. I have filed, my lord, the applications to bring the legal representatives of deceased.
Notice has to go.
Please, my lord.
In pendency of the above matter, respond number 6 is expired, hence IF 4, 5 and 6 have been filed. Issue notice on IF 4, 5 and 6 written by 27 September. 22, during pendency of the matter, respond number 22 also has expired. Hence IS 7, 8 and 9 have been filed. Issue notice on IS 7 and 8 and 9 written by 27 September.
Please, great.
28.
My lord,
Srinivas.
my lord, I appear for petitioner in this case, my lord.
Yes.
My lord, the petitioner herein have called in question annexure E, my lord. It is a communication sent to the SHO, my lord, on 11/1/2024.
For respondent number 5, my lord, I have one small submission. Today I have an inconvenience, personal inconvenience. Kindly on next week it may be placed.
At the request of counsel for respond number 5, released on 26th, interim order earlier granted, is extended.
My lord, it is there, my lord. It is not time bound, my lord. Interim annexure E stayed ಅಷ್ಟೇ ಹೇಳಿರೋದು till next date until.
Now we'll make it time bound till next. ಇಲ್ಲಾದ್ರೆ ಬರಲ್ಲ.
29.
Lord, I appear for the petition, Lord. I have filed an IM, Lord, for amendment pursuant to the amendment, Lord,
5C
to
allowed.
section 5(1)(c).
Amendment to be carried out, amendment petition to be filed, released on 26th.
Lord, the interim order to be extended.
Interim order earlier granted is extended till next day.
Grateful.
Further hearing, serial number 30.
Your lordships had actually fixed the date as 26th. Yeah. That was what our counter in state.
Counter ಹಾಕಿಲ್ವಾ ಇನ್ನ?
Yes, my lord, the statement is ready, my lord, one the draft is ready. Only
A draft has been ready for last 3 weeks.
2 weeks it is. Anyhow, in 3-4 days we will file it, my lord. Maybe next week we will file it.
Not a fair submission. Arguments have been advanced. Learned Advocate General said, let the arguments start. Otherwise, why should we take up the arguments?
Anyhow, it is ready, but in 2-3 days we will.
Argument ಶುರು ಆಗ್ಲಿ 4 ದಿನದಲ್ಲಿ ಹಾಕ್ತೀವಿ ಅಂತ ಹೇಳಿ 3 ವಾರ ಆಯ್ತು.
There. Some difficulty was there to seek government.
What is the difficulty? It's a further hearing matter. You can't be making this submission.
Anyway, within 2-3 days we will file it.
We'll take your objection as not filed.
No.
Hari, my lord.
We'll take your objection as not filed.
Hari, my lord.
Sorry,
My
we
lord.
can't be giving you this kind of time every time. You think that's a
No.
right
No.
that you can ask for?
ನಾಳೆ ಮಾಡೋ.
That ಯಾವಾಗಾದ್ರು ಬಂದ್ಬಿಟ್ಟು time ಬೇಕು ಅಂತ ಹೇಳೋದು.
Anyhow,
The state has not filed its objections despite having granted several adjournments.
My lord,
It appears that the state is not interested in.
tomorrow we will file it, my lord.
The state is not interested in defending the amendment. As such, the objections are taken as not filed. Yes, Mr. Pandit, please go.
Request, my lord, within
Tomorrow.
We have,
today
we have
evening or
had the
tomorrow we will
patience
file it.
3 times. I to 4 times.
Yes, I have. Give me.
And that is because the Advocate General made a submission
Yes.
3 weeks ago.
One day speaks accommodation.
ಮಧ್ಯಾಹ್ನದೊಳಗೆ ಹಾಕಂಗಿದ್ರೆ ಹಾಕಿ. ಅಯ್ಯೋ ಹೇಳಿ ಅವ್ರದ್ದೇನು ಅಬ್ಜೆಕ್ಷನ್ ಇಲ್ಲ.
My lord, ಹೇಳಿ.
Unnecessary
ಇವತ್ತು Monday serve ಮಾಡ್ತೀವಿ ಅಂತ.
We'll serve it on Friday by.
Whenever you want to do it, you can do it. If you want to do it. Yes.
Role ತಗೋಬೇಕಲ್ಲ sir.
Only was not.
You just allow your petition ಅಷ್ಟೇ.
ಹೇಳಿ.
ಏನೂ ಅಬ್ಜೆಕ್ಷನ್ ಇಲ್ಲ.
Non-respondent.
ನೀವೇನ್ ಹೇಳ್ತೀರೋ ಹೇಳಿ.
My lord, ಹೇಳಿ.
You have a right to say.
My
We have
lord.
filed our submissions if your lordship takes.
Yeah, accommodation grant, my file.
Sorry,
Anyhow, ready.
even you, one day ಅಂದ್ರೆ ನಾಳೆ ಬರ್ಬೇಕಾ? ನೀವು ಬರ್ತೀರಾ ನಾಳೆ?
We'll serve the
We
copy.
take it only on Friday.
Monday we will.
We take this matters only on Friday.
Yeah, that's
And we have
what
given you
vote.
enough of time. Please, don't embarrass us and don't embarrass yourself.
Taking only one day time, my lord, that's what.
File ಮಾಡಿ. ನಾಳೆ file ಮಾಡಿ. We have taken it as not filed, file an application for recall, we'll allow it. After you file, not before.
Yeah, that.
Yes.
My lords, we have filed our written submissions if your lordships have that.
ಎಲ್ಲರಿಗೂ ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೀರಾ?
Copy is given to the government that day itself, my lords. Ado written submission with synopsis anta in serial number 30 itself.
ಯಾವಾಗ ಫೈಲ್ ಮಾಡಿದ್ರಿ?
Your lordships have recorded also.
When did you file it?
12/7.
ಅಲ್ಲಿದೆ.
ಅದು ಜಡ್ಜ್ಮೆಂಟ್ಸ್ ಅಷ್ಟೇ ಇರೋದು. ಜಡ್ಜ್ಮೆಂಟ್ಸ್ ಅಷ್ಟೇ. We have set out the paras also.
No, no, my lords,
This
that's
is
why
your
I said.
petition with everything in this. your
Alla,
written
adu-
submission.
That is, no, that comprises judgments. That's why it's big. Otherwise, my submissions, my lords, are not, it's just about,
Your written submissions are bigger than the petition.
my lords, I've given point wise only because of the validity.
I tell you.
My lord.
Copy ನಮಗ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
No, the Amendment Act isn't, if your lordship sees. Necessary judgmental idea.
Yes.
We have enclosed it.
Only thing we have on our board is this matter. Otherwise, we don't have any other work.
I understand, but my mistake was, my lords, they told me it is 26th.
ಅಲ್ಲ ಹಂಗೆ ತಾವು ಹೇಳಿದ್ರಿ. ಆಮೇಲೆ ಇದ್ರಲ್ಲಿ ನೋಡಿದ್ರೆ ಇದರಲ್ಲಿ ತಮ್ಮ ಇದರಲ್ಲಿ 26th ಅಂತಾನೆ ತೋರಿಸ್ತಾ ಇದೆ. ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ಇವತ್ತಿಗೆ ತೋರಿಸ್ತಾ ಇದೆ. Yesterday even I was confused in the evening. But ಇದ್ರಲ್ಲಿ 26th ಅಂತಾನೆ.
Arguments were to be completed last week. The AG was to argue today.
ಅಲ್ಲ ಈ ತಮ್ಮ ಇದರಲ್ಲಿ
It was for AG's argument.
26th ಅಂತಾನೆ ತೋರಿಸ್ತಾ ಇದೆ.
My lord, last date of hearing, I requested 26th, my lord, to file.
If we adjourn this, we have no other work.
My lord, Monday, no, my lord, tomorrow we'll file it, my lord, Monday we'll serve the copy.
Hear the argument.
Please,
My lords, one of the grounds, my lords, which
So
was,
this is resolved.
my lord, only
None
for,
of the SC/ST matters can be taken up.
yes, my lord, part,
That's a big problem.
2 days can be taken up, my lord.
File ಮಾಡಿ.
my lords, in running page 3, we have set out the main grounds in. At para 1, my lords, we say that it does not seek the amendment, the impugned amendment, my lords, does not seek to rectify or overcome the defect and lacuna that had been pointed out by the Apex Court. My lords, in the case of, Nekkanti, Hinduja, my lords, of all, I only refer to Nekkanti because preamble alli avaru, they have referred only to Nekkanti. Nekkanti and Hinduja was virtually the same line, my lords, sir. And also that the said defect or difficulty could not even have been removed. All that this Honorable Supreme Court, by referring to the original enactment, said that when there is no limitation, it should be construed that it should be within a reasonable period. My lord, what the Amendment Act has done, which your lordships would get at page 173 in the writ petition, my lords.
The writ petition.
Amendment Act. Amended writ petition, my lords.
170? Three, make sure R.
It starts at 173.
Yes.
Your lord, that's the statement of objections. Lords, in that, if your lordship kindly come 1, 2, 3, they say what is the act for, and oh, please come to 7, my lords, para 7 at 174 of the statement of objects and reasons.
Para 7.
Clause 7, para 7. The Honorable Supreme Court of India in civil appeal.
You have taken us through.
Yes, my lords. So now at para 8, the lordships have the statement records the observation of the Honorable Supreme Court also, that where a statute provided for a period of limitation should be invoked within a reasonable period. Then please see 9. There is no time limit for applying the restoration of land or to register suo motu case by the competent authority in section 5(1). The government has noticed that the competent authorities have been disposing few of the cases against the main objective of the act by referring to the judgment Honorable Supreme Court. Further, with respect to the Honorable Supreme Court's order, Dalit organizations have requested the government to amend this act in such a way that there should not be a time limit to restore such lands which have been transferred without the prior permission of the government or to register suo motu case by the competent authority. It is announced in para 313 of the budget speech 2023-24 that in order to enable SC/ST land grantees to appeal for restoration of land, suitable amendments will be made to the Karnataka Scheduled Caste and Scheduled Tribes Prohibition of Transfer of Certain Lands Act 1978 by prescribing timeline in the act itself, by prescribing timeline in the act of the road.
Now there's no timeline which has been prescribed.
No, now what they do, amendment is your lordships will get at 176.
So the budget speech said, we'll prescribe a time.
Timeline on timeline, my lords, that's what, when they say timeline, but now please see what they have done at 176. That's, my lords, section 2 of the Amendment Act, where they have amended section 5 by introducing, my lords, a non-obstante clause.
So timeline has become no limitation of time.
No limitation at all. Notwithstanding anything contained in any law, there shall be no limitation of time to invoke the provisions of this act. And at D, clause D of the Amendment Act, clause C is inserted and clause D, which directly, that's our case, that it directly, my lords, infringes the judicial powers. D, the provisions of clause C shall apply to all cases pending before all competent authorities and all courts of law adjudicating the cases under this section. These are the two amendments brought about. One non-obstante
This
clause.
clause D would make it retrospective.
Retrospective. Both, my lord, C and D. C also virtually, if C and D are read together, my lords, it becomes all, since D they are applying this law, the effect of clause C, my lords, it is with retrospective effect itself.
What happens to cases which are not pending?
Then C will apply, they will apply C.
So even then it will become retrospective.
My lords, it is a retrospective amendment because in pending cases, they say this will apply. So far as new cases, anybody who can, now, my lords, anyone can file a case, the limitation aspect will not even be considered. That's like wiping away Nekanti's case. Because there is no limitation.
So would it mean that if orders have been passed pursuant to Nikanti's case, they can be again reopened under C?
My lords, it cannot be reopened unless they, suppose, my lords, there is a writ petition or a deputy commissioner, writ petition decided on basis of Nekanti. And if there is a writ appeal pending, D would apply it straight away.
Suppose even writ appeal has been dismissed and then SLP is filed today.
SLP is filed, my lords, SLP, that will apply again.
Until a finality is reached.
Yes.
In a SLP, C would apply to any situation.
Any situation. Oh, my lords, of course, if the...
But there's some submission made that it won't be retrospective. What the submission was made, it was only prospective and then a submission. Anyway, you can argue that.
Please.
Because, my lords, if the SLP is decided or if it has attained finality, they cannot reopen, my lords, in spite of this. But if there is a case pending, yes.
Then the regular concept of res judicata would apply.
Yes.
Making a finality and
that attains any amendment, my lords, they can't reopen again. But if there is a, when there is a case pending, yes, they are going to apply this.
what is case pending could also mean the next stage of the case.
Any stage. Suppose, my lord, there is a case one, the lowest stage is the assistant commissioner. If suppose after 100 years, somebody has filed a case and it is pending without being adjudicated, Nekanti's case would have applied. But now, virtue of the clause C, in that case, because it says all cases pending before all competent authorities and courts of law. So, AC, assistant commissioner, deputy commissioner.
So both suo motu powers as also an application will get covered under C.
C. Any case, all the cases will get covered under C.
And
Before the authority
pendency of the matters will get covered under D.
D.
before competent authority or courts of law.
All courts of law.
Yes.
That's the effect of the amendment, my lords.
Where is the budget speech? Have you produced the budget speech?
No, my lords, we have not got the budget speech. We have relied on the statement of objects and reasons which says that. And also clause 12, my lords, para 12 at 175 of the statement of
That is what
objects.
we are going to ask you now on that.
They
Clause
say,
12 says
as per the
observation
made by the Honorable Supreme Court antare. Now, my lords, to our Honorable Supreme Court has never made any observation regarding amendments to be brought about or anything. All that the Honorable Supreme Court in Nekanti's case, if your lordships recollect, has decided is since there is no limitation prescribed under section 5 of the SC/ST Act, it should be construed to be within a reasonable period.
we produce Nekanti.
Nekanti adu ನಾವು ಹಾಕಿಲ್ಲ ಕೊಟ್ಟಿಲ್ಲ ಅಲ್ವಾ?
In your compilation.
ಅದ್ರಲ್ಲಿ ನೆಕ್ಕಂಟಿ ಮಾತ್ರ ಹಾಕಿಲ್ಲ. That's the ನೆಕ್ಕಂಟಿ and ಹಿಂದೂಜಾ were required. I thought
ಎರಡು ವಾಲ್ಯೂಮ್ ಅಲ್ಲಿ ಅದೇ ಮೇನ್ ಎರಡೇ ಬಿಟ್ಬಿಟ್ಟು
ಅದು ಎರಡು ಮಾತ್ರ. What's ಮುಂದ್ರಲ್ಲಿ ಹಾಕಿಲ್ಲ.
You are required to produce both, alva?
Let's.
As per the observation of the Honorable Supreme Court and announcement in the budget speech, both of which you have not produced.
Nekanti somehow, those two have got mixed.
The budget speech also you will have to produce because
Budget speech, my lords, we have not been able
to
to.
be only on that basis.
Otherwise, the government can produce the budget speech, my lords. After all, they have the custody, immediate custody. I can apply and get it, but that may take some
It's
time.
already in the public. As per clause 12, hence it is proposed to amend
170.
as per the observation made by the Honorable Supreme Court and announcement made in the budget speech. So those are the two reasons which you are given. Apart from that, finally, it is only these two. So what does the budget speech say and what does?
Will produce, my lord.
This
Budget speech ಕೂಡ ಮಾಡಿದೆ.
Now, please see Nekanti's judgment if your lordships have, my lords. Para 4, my lords.
India Kanun ಕೊಡಬೇಡಿ Mr. Panindra.
My lords.
India Kanun, it says.
Ayyo,
section-
bad.
It
Lords,
says section 52, there
I
is no
have
section
the-
52 in the act.
SCC ನನ್ನ ಹತ್ರ 2014 SCC, my lords.
ಅದು ಕೊಡಿ, ಇದು
232.
ವರ್ಡೇ ಪ್ರಾಬ್ಲಮ್ ಇದೆ ಇದ್ರಲ್ಲಿ.
ಅದು ಬೇಡ ಅದು. Lord, because I also rely only on SCC because it's more.
Here's the true print. Or now you can actually take a
Budget
printout from
speech
the
ಇದೆಯಾ?
website. With a neutral
Lords,
citation.
budget
that is
speech, I will get it. I've got the soft copy.
para 4.
ಇಷ್ಟೇ ಹೇಳುತ್ತೆ ಅದು 313 para 313 my lords of the budget speech. I'll read it. It's about 5 lines ಅಷ್ಟೇ. In order to enable SC/ST land grantees to appeal for restoration of land, suitable amendments will be made to Karnataka Scheduled Caste, Scheduled Tribes prohibition of transfer of certain lands by prescribing timeline in the act itself. That's the budget speech.
So that is para
313.
11.
Para, yes, 313 ಅಂತ ರೆಫರ್ ಮಾಡಿರೋದು budget speech. In para 11 ಅಲ್ಲಿ. That's the only thing. Para 8 minutes. At 235, page 235. The lordships at para 7 observed that the validity of the act had been upheld in Manchegowda, which also carved out a exception, and at para 8 minutes. It starts with however, the lordship gets it. Yes. However, the question that arises is with regard to terms of section 5 of the act, which enables any interested person to make an application for having the transfer annulled as void under Section 4 of the Act. This section does not prescribe any period within which such application can be made. Neither does it prescribe the period within which suo motu action can be taken. This court in Chedilal Yadav versus Hari Kishore Yadav and also in Ningappa versus Commissioner reiterated a settled position in law that whether statute provided for a period of limitation, provisions of the statute must be invoked within a reasonable period. It is held that the action, whether on an application of parties or suo motu, must be taken within a reasonable time. That action arose under the provisions of a similar act which provided for restoration of certain lands to farmers which were sold for arrears of rent or from which they were ejected for arrears of land from 1/1/1939 to 31/12/1950. This relief was granted to farmers due to flood in Kosi River, which make agricultural operations impossible. An application for restoration was made after 24 years and was allowed. It is in that background that this court upheld that it was unreasonable to do so. We have no hesitation in upholding that the present application for restoration of land made by respondent Rajappa was made after an unreasonably long period and was liable to be dismissed on that ground. Accordingly, judgments of Karnataka High Court, namely R. Rudrappa versus Commissioner, Madhu Rudrappa versus Karnataka, and G. Maregowda versus Commissioner, holding that there is no limitation provided by Section 5 of the Act, and therefore an application can be made at any time or overruled. Order accordingly. This was again
that this observation made that it does not provide for limitation. They can always amend it on that basis.
Yes, now, my lords, they could have provided for a limitation. What by amendment, what they say is there is no limitation. Whether that amounts to providing a limitation is the issue. And their entire, my lords, if your lordship sees their statement of objects and their budget speech, they said we are going to provide a timeline. Instead of that, there is no timeline itself.
That also is a timeline.
That, my lords, that is the issue. If there, that's why, my lord, I said, irrespective of the amendment being struck down, if we go back to all the settled position, my lords, if there is no limitation, now what the Act says is there is no limitation to invoke. If there is no limitation to invoke, it should still be within a reasonable period. Can it be held that
if there is no timeline prescribed, then it has to be within a
reasonable period?
You're right, and that's what the apex court has also said. But if, for example, there could be three, this one, there is no timeline. Two, there could be a timeline
prescribed
specified.
time.
5
Or
years,
they
20
say
years, 30 years, 50 years, and so on.
Understand.
Or it could say that
timeline is infinite.
so that infinite is also a timeline.
Timeline is whether that would offend, my lords, whether that becomes arbitrary is another issue. An infinite timeline itself. Now, my lords, earlier the view was constitutional validity could not be challenged on the ground of arbitrariness. Now, my lords, that view has changed. It can still become, my lords.
So you want to invoke manifest arbitrariness?
Yes. That has now.
Cannot the state has the power to prescribe the timelines.
Timeline, yes.
To say there's no timeline is also a timeline.
That's what. Yes, absolutely.
Powers are there with the legislature.
That's why, my lord, so far as their power to, we are not challenging on that. That has been settled. The issue is whether this would direct two issues. There would be three issues. One is, my lords, whether this, our interpretation is this prescribing that saying that there is no timeline itself falls within that Nekanti's ambit. Suppose it is construed to be infinite, then it becomes manifestly arbitrary.
So your grounds.
The third is by giving it a retrospective effect, you are directly infringing on the judicial powers which has settled the position. Whether the foundation has been taken away is the issue before, my lords.
What is your first contention?
One is, my lords, that the amendment is manifestly arbitrary by prescribed, or my lords, that would be my third argument. One is it infringes on the judicial power itself by giving it a retrospective effect.
It takes away the foundation of the
foundation. It does not take away the foundation. It does not take away the foundation. And it has attempted to overrule the judgment of Nekanti.
in recovery you will want to.
Yes. Then, my lord, the other would be,
The second contention.
second would be, my lords, that since there is no timeline prescribed, it would still fall within the ambit of the judgments which had been decided in McConty, that it should still be within a reasonable period.
Third is manifest arbitrary.
Manifest arbitrary. When if it is construed to be infinite, if the timeline is infinite, that, my lords, would be manifestly.
Yes.
My lords, there was one more judgment which unfortunately is not found. McConty was followed in Vivek Hinduja, which also went a little more. I've given the citation, unfortunately it is not there. That's, my lords, 2020-14 SEC 228.
Ilva copy ilva.
Yes,
Copy idea.
my lord, I have it copy.
Yes.
Lords, your lordship gets that, my lords. This also was against a judgment, my lords, on the thing. If your lordship kindly come to from para 4, my lords, I'll read. At page 230. It starts with arguments have been addressed. Arguments have been addressed before us at length on whether the present appellants had perfected their titles on the date of coming into force of the Karnataka Act. We are not inclined to go into this question because the instant matters can be decided on an aspect settled by this court in Cheddilal Yadav versus Harikishore Yadav and McConty Ramalakshmi versus State of Karnataka. In these two decisions, one of which arose under the Karnataka Act, this court has held that the authorities entrusted with the power to annul proceedings purported to have been made by the original grantees must exercise their powers to do so, whether on an application or suo moto within a reasonable time, since no time is prescribed by law for taking such action. In the decided cases, action has been initiated after about 20 to 25 years of the coming into force of the Karnataka Act. In the present cases, it's undisputed that the action had been initiated after almost 20 years from the coming into force of the Karnataka Act. In principle, we do not see any reason why the delay in the present cases should be considered to be reasonable. There is no material differences between the period of delay in the present cases and decided cases. Relying on some observations in Manchegowda versus State of Karnataka and Sunkara Rajalakshmi versus State of Karnataka, Fernandez, Learned Counsel on respondent side submitted that the outer limit for initiating action should be 30 years. We, however, find that the observations in those cases are not apposite and are made with reference to period of prescription in respect of government properties under the Limitation Act 1963. It was also submitted on behalf of respondents that Section 4 of the Karnataka Act annuls a transfer made in contravention of itself. Therefore, it makes no difference if the proceedings are initiated even after 20 to 25 years. We do not find it possible to accede to this submission. This court in Port of Kandla versus Hargovind Jasraj reiterated the necessity of an order of competent court or tribunal before which impugned order can be declared as null and void. Then, my lord, their lordship, para 10, if your lordship comes, my lord. In Pune Municipal Corporation versus State of Maharashtra, this court reproduced the following observations with regard to declaration of orders beyond the period of limitation as invalid. Setting aside the decree passed by all courts and referring to several cases, this court held that if the party agreed by invalidity of an order intends to approach the court for declaration that the order against him was inoperative, he must come before the court within the period prescribed by limitation. If the statutory time of limitation expires, the court cannot give declaration. We are in respectful agreement with the aforesaid observations. It is, however, necessary to add that where limitation is not prescribed, party ought to approach the competent court or authority within a reasonable time, beyond which no relief can be granted. As decided earlier, this principle would apply even to suo moto actions. So, my lords, where their lordships held, if the limitation itself is not prescribed, that means, my lord, it is an infinite issue. If limitation is not
Already infinite at that time.
at that point of time, so even in such a situation, the lordship sold, it should be within a reasonable period. Now, if you're going to bring in an infinite period now, can that, my lords, go beyond the scope of these two judgments?
The infinite period that you are speaking of earlier is by implication.
Yes, by implication.
Now the infinite period has been brought in expressly.
Yeah, expressly. Whether that would change the situation itself. Even by implication.
And the apex court did not accept 30 years.
Yes. It did not.
Accept 30 years.
In Hinduja also, it did not, my lords. Even in, of course, in Nakanti, it was the first one. Now, my lords, I would also, the fourth limb, I don't know whether I will be correct, my lords, though I'm not too confident. This amendment could also, my lords, overturn the observations in Manchegowda's case. Because the Manchegowda's case, it held long uninterrupted use, could also, where it was voidable, could not be rendered void is what Manchegowda's case held, my lords, while upholding the validity.
Para 24.
Now this, yes. Now this judgment which does not provide for, amendment, does not provide for a limitation. Lords, somebody can after 100 years can file now.
Unless
Because-
already decided.
That would also,
So you are now putting it across, all the judgments will be overruled by the Santana. What is your
my
submission?
lords, my lords, suppose, my lords, somebody has not filed an application, I'll assume myself. Manchegowda's observation is there, man. Today, because of this amendment, after 100 or 150 years, he'll file an application. Now the purchasers or the line of purchasers, they could have taken a contention, or their law was that if there is a long uninterrupted use, what was voidable, they lost their title. Now that even, I can't even take that ground because there is no limitation. The grantee will say there is no limitation, so whether it is long uninterrupted use or not, your title goes. Because I have a right to initiate action at any point of time. It's infinite.
Let us test your argument. If we have to test your argument.
That would be the last. That's it.
If they had given a figure like 50 years.
Yes. Whether I could still
You've been
challenge.
saying 100 and 150 years. So if they had given a figure of 100 years, would that be valid?
But I would still challenge it on the ground of being manifestly arbitrary. Limitation should be within a reasonable period, my lords. That's the issue. If your lordship sees any enactment over a period of time, for everything there is a limitation provided. Yes.
Against the government, 30 years.
That's
They could
30
have
years.
fixed
Yes.
30 years.
That is for adverse possession, yes.
You
Maybe.
can't have a case for 30
At
years.
that point of time, maybe I would have lost, though I would have challenged it, saying it's manifestly arbitrary, but that would be only against the government. My lords, 30 years comes, my lords, for adverse possession.
Again, if we have to split it into two, one is suo motu proceeding and two is an application.
Yes,
The suo motu could be done within 30 years.
30 years, probably, yes. Maybe, yes.
If it is an application filed for resumption under subsection 3 of section 4, that would
Purely-
have to be within a reasonable period.
Reasonable period. What is the reasonable period? At least 10 to 12 years. My lords, normally for adverse
individual, 12
possession,
years,
12 years is
109.
12 years. That is how, my lords, they have construed it. Now today, my lords, if you are going to fix a infinite period, whether that is arbitrary or not is the issue. One is whether it apart from other grounds, whether it can be. One is,
Can there be two limitations? One for the state under suo motu and one for the.
now there is nothing like that. In the present impugned amendment, there is nothing. Both of
We'll
them
have-
can do.
We'll have to test the argumental.
Yes, yes, let's, of course.
Because if we say for the government and suo motu proceeding, because both are covered.
Both are covered. Here, both are covered.
Suo motu, when the government, against the government, there's already a maximum limitation period of 30 years.
30
which
years
is
for
provided.
claiming adverse possession.
So that can be a reasonable period.
Somewhere, yes. Whether it could be construed as a reasonable period for that, yes.
Insofar as the application filed by this one, what is reasonable will again change.
Change. Now here they've made it infinite. Because at each stage, my lord, there could be change of positions. We are talking about generations here. Now, my lords, if you make it in, no doubt the act was for welfare of the scheduled caste and scheduled tribe act. Object of the act is good. But whether such an amendment which the state has proposed would run contrary to the declaration of law. Even if there is no, it's like this. If the court says by implication, if there is no limitation, it should be within a reasonable period, merely because you bring it within the words, whether that object is lost. There was no limitation under section 5. Today, the position is there is no limitation.
See, even the purchaser is aware that the sale could not have happened.
Yes.
The purchaser cannot, you are representing the purchaser.
I am representing.
You cannot say, I did not know, I purchased
No,
it
in
by
this
myself."
case, yes, he could, but my lords, till what point of time is the issue?
When you could not even have purchased it.
My lords, at a point of time which happened, that's why, my lords, they brought in the concept. My lords, in Nekkanti, Hinduja, every case, the purchaser probably was not aware that there was a violation. That's why, my lords, it could have been avoidable.
Can he not be aware of the violation? 4 and 5 are clear.
My lords, section 5 came into in 78, but it gave effect to all the transactions which had taken place earlier also. Even in those circumstances, my lords, yes.
See, this has lot of parts and subparts. So prior to 79, Manchegowda is actually taking care of the situation.
Maybe after 78, people were aware. After 78, yes.
78, the purchaser cannot say, I did not know.
I did
If
not.
he has
Yes.
purchased it post 78.
Post 78.
Post 78, there's also a mandate for permission from the deputy commissioner to be obtained prior to the sale.
Yes.
So if a deputy commissioner's permission has been obtained, it goes on a different footing. If it is not obtained, it becomes a different footing.
Yes, absolutely.
So he cannot say that he did not know.
Ignorance is no excuse.
No
yes.
excuse.
But, my lords, to initiate action, suppose it's to initiate action, my lord, under 79AB, my lord, there were cases under the Land Reforms Act. A non-agriculturist or a person who had more than 2 lakhs income could not purchase, my lords, agricultural land. Knowing that if I purchase, violating 79AB, there also there is no period that was fixed under the enactment. This court, my lords, held, even in such a situation, it should be within a reasonable period. There the authorities could invoke that. Suo moto. This court held, my lords, it should be within a reasonable period.
So even in pari delicto will get covered there.
It has to, my lords, otherwise there will be change of possessions. Now, my lords, I will change my possession. Suppose a transaction has taken place 60 years ago. Subsequent 3-4 transactions would have occurred. Properties would have got developed. Change of generations would have gone in. And at an infinite stage, after 100 years, somebody files an application and says the sale in 1920 is void. Is that the object for which this act came into force?
That depends on your fourth argument, whether Manchegowda will also stand overruled.
Yes.
If Manchegowda doesn't stand overruled,
then, my lords, yes.
And this is the act which comes into force from 1978.
78 it has come in, but that's why, my lord, I am saying whether it is manifestly arbitrary or whether it strikes down those first 3 elements. If your lordship comes to the conclusion that it directly infringes on the judicial power, that's one thing. Second, or otherwise, if your lordship holds that it is manifestly arbitrary because it's infinite, subject to, my lords, of
we'll have to answer all the conditions.
yes. No, I'm just
keep it to one.
Absolutely. Lord, I am only saying if it is manifestly arbitrary,
there will
then
be many more arguments which will come from this side.
I am expecting, my lords. In fact, I have just started. I know, my lords, I also have it's not as easy, my lords, when we start on the constitutional validity.
At the end of the day, we'll have to also keep in mind that this is a beneficial legislation.
That's why I said it. The object is there. Whether this object is sought to be, my lords, by this amendment, whether that is the issue.
Yes.
The object of the act was only for the beneficial, it's a beneficial legislation. That has been, the validity of the act has been upheld, my lords. I can't go beyond that. Today is it whether this limitation, what they are now prescribing, whether that is manifestly arbitrary.
Yes.
That's the issue. On those issues, my lords, we have actually gone in our written submissions on each, and we have given the citations with paras for that each proposition, if your lordship takes my written submission. That, of course, may change, my lord, subject to their filing a counter or, my lords,
Volume 1.
Because on what? Yes, my lords.
Yes.
At page 3, my lords. In that para 1, main grounds of challenge. Before that, we have just spelled out the background without going into facts. The Karnataka Scheduled Castes and Scheduled Tribes Prohibition of Transfer of Certain Lands Amendment Act does not
You
seek.
won't be getting into the facts of each of these.
No, no facts, my lord. This is only because of the.
Decide on the constitutional validity. Then on the facts of each.
Your lordships have already indicated. That's why I have not gone into facts at all in this.
Last time when you started only, we told you.
My facts do not even touch this according to me. So therefore, let him complete. And ಅದಕ್ಕೆ ತಾವು ಹೇಳಿದ್ರಿ last time also.
Does not seek to rectify or overcome the defect and lacuna that had been pointed out by the Apex Court in its judgment dated 26/10/2017, as the said defect or difficulty could not have been removed. The said Amendment Act has been brought about only for the purpose of circumventing the judgments of Apex Court and this court. Now, for this proposition regarding, my lords, what we have stated, we have relied on, my lords, 2 judgments. One is, my lords, 2014, and that's in the case of Amarendra Kumar Mahapatra. And, my lords, Madan Mohan Pathak, which is the first of the judgments where their lordships held an amendment which tries to interfere with the judicial orders, then the basis has to be removed.
Yes.
Lords, now I'll first take your lordships to Madan Mohan Pathak, my lords, that's at running page 46. Because that's the earliest judgment which running page 46, your lordship may come.
Yes.
This was regarding a settlement arrived at which was sought to be overturned by the amendment, my lords. In that, please come to para 9, which your lordship should get. At, my lords, running page 66. It starts with Life Insurance Corporation.
Yes.
The Life Insurance Corporation leaned heavily on the decision of this court in Shri Prithvi Cotton Mills versus Borough Municipality in support of its contention that when the settlement insofar as provided for the payment of annual cash bonus was set at naught by the impugned act with effect from April 1, 1975, the basis on which the judgment proceeded was fundamentally altered, and that rendered the judgment ineffective and not binding on the parties. We do not think that this decision lays down any such wide proposition as is contended by on behalf of the Life Insurance Corporation. It does not say that whenever any factual or legal situation is altered by retrospective legislation, a judicial decision rendered by a court on the basis of such factual or legal situation prior to the alteration would straightaway without more cease to be effective and binding on the parties. It is true that there are certain observations in this decision which seem to suggest that a court decision may cease to be binding when the conditions on which it is based are so fundamentally altered that the decision could not have been given in the altered circumstances. But these observations have to be read in the light of the question which arose for consideration in that case. There, the validity of the Gujarat Imposition of Taxes by Municipalities Validation Act 1963 was assailed on behalf of the petitioners. The Validation Act had to be enacted because it was held by this court in Patel Govardhan Das Hargovind Das versus Municipal Corporation that since Section 73 of the Bombay Municipality Boroughs Act 1925 allowed the municipality to levy a rate on buildings or lands, and the term rate was confined to an imposition on the basis of annual letting value. Tax levied by the municipality on lands and building on the basis of capital value was invalid. Section 3 of the Validation Act provided that notwithstanding anything contained in any judgment, decree or order of a court or a tribunal or any other authority, no tax assessed or purported to have been assessed by a municipality on the basis of capital value of a building or land and imposed, collected or recovered by the municipality at any time before the commencement of the Validation Act shall be deemed to have invalidly assessed, imposed, collected or recovered, and the imposition, collection or recovery of the tax so assessed shall be valid and shall be deemed to have always been valid, and shall not be called in question merely on the ground that the assessment of the tax on basis of capital value of the building or land was not authorized by law, and accordingly any tax so assessed before the commencement of validation act and leviable for a period prior to such commencement but not collected or received before such commencement may be collected or recovered in accordance with the relevant municipal law. It will be seen that Section 3 of the impugned act, the legislature retrospectively imposed tax on building or land on the basis of capital value, and if the tax was already imposed, levied and collected on that basis, made the imposition, levy, collection and recovery of the tax valid, notwithstanding the declaration of the court that as rate the levy was incompetent. This was clearly permissible to the legislature because in doing so, the legislature did not seek to reverse the decision of this court on the interpretation of the word rate, but retrospectively amended the law by providing for imposition of tax on land or building on the basis of capital value and validated the imposition, levy, collection and recovery of tax on that basis. The decision of this court holding that the levy of tax to be incompetent on the basis of unamended law therefore became irrelevant and could not stand in the way of the tax being assessed, collected and recovered on the basis of capital value under the law as retrospectively amended. That is why this court held that the Validation Act was effective to validate imposition, levy, collection and recovery of tax on building on the basis of capital value. It is difficult to see how this decision given in the context of a validating statute can be of any help to the Life Insurance Corporation. Here, the judgment given by the Calcutta High Court, which is relied by the petitioners, is not merely a declaratory judgment holding an impost or tax to be invalid so that a validation statute can remove the defect pointed out by the judgment, amending the law with retrospective effect and validate such impost or tax. But it is a judgment giving effect to the right of the petitioners to annul annual cash bonus under the settlement by issuing a writ of mandamus directing the Life Insurance Corporation to pay amount of such bonus. If by reason of retrospective alteration of the factual or legal situation, the judgment is rendered erroneous, the remedy may be by way of appeal or review, but so long as the judgment stands, it cannot be disregarded or ignored, and it must be obeyed by Life Insurance Corporation. We are therefore of the view, irrespective of whether the impugned act is constitutionally valid or not, so and so is bound. Now, my lords, constitutional thing, they went into that issue. That is how, my lord, their lordships held that the foundation has to be removed or the defect which was pointed out in the earlier judgment. If you're going to take out that.
Para deals with the constitutional validity in this?
My lords, it starts from, my lords, ground A, para 10 onwards. At page 68 itself. That whether that bonus itself amounts to annual cash bonus amounted to property is considered, my lords. Then, my lords. The lordships went into that issue after holding, my lords, whether it removes that was what was considered, but their lordships hold that the act was not fundamentally altering the judgments which was rendered by the Calcutta High Court.
So the judgment will continue to be binding.
Yes, that will continue to bind the parties. Now, my lords, in the other judgment which I cited, that's my lords Amarendra Kumar Mahapatra, which starts at para 9. This was relating to a regularization and promotion issue. In that para 25, my lords, which your lordships would get about again. Invalidity and to validate, my lords, at para 25 at running page 25. This is, my lords, Amarendra Kumar Mahapatra and others versus State of Orissa.
Hmm.
Which also relied on Madan Mohan Pathak, but para 25 minutes, judicial pronouncements anta shuru agutte. Running page 25. Judicial pronouncements regarding validation laws generally deal with situations in which an act, rule, action, or proceedings has been found by a court of competent jurisdiction to be invalid, and the legislature has stepped in to validate the same. Decisions of this court, which are the legion, take the view that while adjudication of rights is essentially a judicial function, the power to validate an invalid law or to legalize an illegal action is within the exclusive province of the legislature. Exercise of that power by the legislature is not therefore an encroachment on the judicial power of the court. But when the validity of any such validation act is called in question, the court would have to carefully examine the law and determine whether one, the vice of invalidity that rendered the act, rule, proceedings, or action invalid has been cured by the validating legislation. 2, whether the legislature was competent to validate the act, action, proceedings, or rule declared invalid in the previous judgments. And 3, whether such validation is consistent with the rights guaranteed by Part 3 of the Constitution. It is only when the answer to all these 3 questions is in the affirmative that the Validation Act can be held to be effective, and the consequences flowing from the adverse pronouncements of the court held to have been neutralized. Decisions of this court are quoted there. Then, my lords, please come to, my lords, para 20, from 26, I'll read, my lords, a few para, because that gives a continuity. Yes. Even in the realm of service law, validation enactments have subsequent to the pronouncement of competent courts come about validating the existing legislation. Decisions of this court in so and so deal with that category of cases. In the case of hand, State of Orissa had not suffered any adverse judicial pronouncement to necessitate a validation act, as has been the position in the generality of the cases dealt by this court. The title of the impugned legislation, all the same, describes the legislation as a validation act. The title of a statute is no doubt an important part of an enactment and can be referred to for determining the general scope of the legislation. But the true nature of any such enactment is always to be determined not on the basis of label given to it, but on the basis of its substance. In MPV Sundar Ramaiah Company versus State of AP, this court was considering whether the impugned enactment was a validation act in the true sense. This court held that although the short title as also the marginal note described the act to be a validation act, substance of the legislation did not answer that description. This court observed, it is argued that to validate is to confirm or ratify, and that can be only in respect of acts which one could have himself performed, and that if Parliament cannot enact a law relating to sales tax, it cannot validate such a law either, and such a law is accordingly unauthorized and void. The only basis for this contention in the Act is its description in the short title as the Sales Tax Validation Act and the marginal note to Section 2, which is similarly worded. But the true nature of a law has to be determined not on the label given to it in the statute, but on its substance. Section 2 of the Impugned Act, which is the only substantive enactment therein, makes no mention of any validation. It only provides that no law of a state imposing law tax on state shall be deemed to be invalid merely because such sales are in the course of interstate trade or commerce. The effect of this provision is merely to liberate the state laws from the fetter placed on them by Article 286(2) and to enable such laws to operate on their own terms. We may also refer to Maxwell's interpretation of statutes 12th edition, where on the basis of authorities on the subject, short title of the act has been held to be irrelevant for the purpose of interpretation of the statutes. Lord Moulton in Watcher and Sons versus London Society of Compositors described the short title of an act as follows. A title given to an act is solely for the purpose of facility of reference. If I may use the phrase, it is a statutory nickname to obviate the necessity of always referring to the act under its full and descriptive title. Its object is identification and not description. My lords, why we have referred to this is, this may not in the lords, this may, though the state does not say it's a validation act, the judgment says though if the court has not struck down any act or not, still if the state wants to validate some action of its, then, my lords, it can still bring out an act. Now, my lord, this is not in a strict sense a validation act, because they are not validating any action. But though they would validate an action pursuant to the clause D, because that gives it a non-retrospective effect.
Validation is of which act? Suo moto action taken by the Tahsildar?
Or anyone. Now, my lords,
That could be a validation.
My lords, what?
When action is taken by individual.
Individual, now we are validating even that act. The action, my lords, I would submit is an action by the assistant commissioner or a deputy commissioner. It's initiated.
The order passed by the
assistant commissioner or a deputy commissioner, whoever it is. My lords. That we are going to validate now by clause D. Because that would, my lords, suppose the court has today categorically held it should be within a reasonable period. Now we have given it a retrospective effect. And, my lords, suppose, my lords, the AC, my lords, I am only giving illustrations to test this proposition. AC has held, following Nekanti, that there is no limit. And this is barred by limitation, not within a reasonable time. Now we are, by clause D, you are now bringing about this amendment to validate an action to say that that order is wrong. Though the normally validation acts are, my lords, brought about to set right an act, the judgment of the court, or, my lords, if an act is struck down. So you are trying to bring into validate.
Illegal act, legal.
Illegal. Now you are virtually doing that is our submission.
How does that amount?
Lords?
Because the action on part of the assistant in suo moto proceedings is not illegal per se. What is required to be determined is by the assistant commissioner or by the deputy commissioner and thereafter by this court as to whether it has been taken in reasonable time.
Reasonable period. Now
that reasonable period interpretation is the issue.
That has been sought to be removed, though I would not say.
We'll come to that later. But the fact remains that the assistant commissioner, the deputy commissioner in this court, or even the Tahsildar in suo moto proceedings, had the power to excise.
He had the power to exercise. Absolutely.
Power, there's not a question of there being no power. Whether
It's only
it could
the
be
assistant
excised
commissioner.
within that period or not is a issue.
Yes.
But the validation acts are always in a situation where there was no power at all.
At all.
And or the exercise of such power would have been illegal. Then the question of validation would apply. Here, there's no validation per se.
Per se, there is no, my lord. I'm only saying, that's why, my lord, I said here, issue is whether clause D amounts to validating something else. If it was an illegal act, you are validating now by clause D by applying this amendment.
Would it be?
Because I'm only hoping what the state would say, my lords. I would have ignored probably based on the reply, I would have seen, my lords, what I would have to, but here we are handicapped and we are going ahead with the.
You are not handicapped, you are in a better position because you don't have it.
Now, my lords, the next one is, my lords, at para 2 in 4, I have, because for each judgment, I have given the separate paragraphs, my lords.
Yes.
At page 4. That is, my lords, to say, for the proposition, it has attempted to overrule or set aside decisions in Nekanti case.
Yes.
On a reading of the words used in the impugned Karnataka Scheduled Caste and Scheduled Tribes Amendment Act, it is plain that the legislature has attempted to overrule or set aside the decisions of Apex Court in the case of Nekanti and Hinduja, and also a series of judgments rendered by Apex Court as also judgments rendered by this court. For that proposition, my lords, 1971 SEC 509 has been relied on, which your lordships would get at running page 96. The judgment starts from 96 onwards. The Constitution Bench judgment, my lords. This also related to, of course, a validating act. But then, my lords, the words used, that's how their lordships went by considering all the judgments at para 10 at running page 101. The third sentence or the fourth sentence in para 10 on the words used in the act, your lordship gets it, my lords, in para 10 at page 101. Plain legislature attempted to overrule or set aside decision of this court. That in our judgment is not open to the legislature to do under our constitutional scheme. It is open to the legislature within certain limits to amend the provisions of an act retrospectively and to declare what the law shall be deemed to have been. But it is not open to the legislature to say that in a judgment of a court properly constituted and rendered in exercise of its powers in a matter brought before it shall be deemed to be ineffective and the interpretation of the law shall be otherwise than as declared by the court.
They have not said this.
Lords, if your lordship sees D, clause D, that's exactly what they're saying. Lords, in the Amendment Act. Though they don't use here, except using the word notwithstanding anything in any judgment. Lords, they said at clause C, notwithstanding anything contained in any law. Now, my lords, declaration of law is law would also amount to declaration of law. And at D, they say, provisions of clause C shall apply to all cases pending before all competent authorities and all courts of law adjudicating the cases under this section. So, my lords, any case pending before this court also. Now, my lords, they say you have to adjudicate only pursuant to C and notwithstanding any law. That is, my lords, even the judgments rendered by the court.
They haven't said Nikanti
They
is
have-
bad law.
Lords,
They haven't said Nikanti is bad law or Nikanti's
they
judgment will be
don't,
ineffective.
except, my lords, they don't say it's bad. That's why, my lords, the object and reasons, if your lordship reads the object and reasons, they only say, Nikanti said this is should be within a reasonable period of time. We are fixing the timeline is what they said. But when they bring about the amendment, they say no timeline, and also at clause D, they say, notwithstanding anything, the provisions, any case should be decided only based on clause C, notwithstanding the law. Though they don't use the particular words, the reading of C and D would only give that conclusion. ಬಿಡಿ ಅದು ಗೊತ್ತು ಬಟ್ ಕಷ್ಟ. Yes. Then, my lords, para 3, virtually, my lords, para 3, 4 and 5, which I have cited.
3, 4, 5 of?
My written submissions, my lords. Is almost on the same lines, except, my lord, saying that it makes a direct inroad. Para 3, almost on virtually on the same. Para 3 at running page 4 of my synopsis. Impugns Act, Amendment Act makes a direct inroad into judicial powers of the state. Adjudication of rights is essentially a judicial function. Legislature cannot interpret the law, but it is only the courts that are empowered to interpret the law. The law is anti-judgment validation, directly overruling the judgment in Nikanti. For that proposition, there are 4 judgments, which, of course, Amendra Kumar Mahapatra, which I already read to your lordships, but then there are other 3 judgments, my lords, on almost same issues, whether it is, and I've given the para numbers also.
Yes.
That your lordship should get Municipal Corporation of City of Ahmedabad at page 103, my lords, running page 103.
Para?
Relating to amendments, my lords. This also was, my lords, most of these amendments relate to trying to validate a tax or a levy, which was, that's how, my lords,
Whether this amounts to validation is something that you need to.
yes, whether this amounts to validation. But that's how we are trying to read it. To say by bringing about this, we are just trying to take away the effect of declaration of law by the Supreme Court, which says it should be within a reasonable period when there is no limitation. Here, my lords, the lordship kindly come to my lords. What was the validity which was tried at para 6 at page 108? Validity, it starts with this, takes us to validity of subsection 3 of section 152A introduced into section by means of an ordinance. That provision reads, notwithstanding anything in any judgment decree. Here, those words are missing in ours. Though in the object and reasons they have given that. It shall be lawful and shall be deemed always to have
I
been
put it across that the amendment is necessitated on account of the observation made in Nekanti.
in Nekanti. That's how they put it across.
It is notwithstanding what is said in Nekanti.
They don't say, they don't use the words.
But your contention is that it impliedly.
Impliedly, it is overruled, my lords. Nekanti only said this, my lords, again, Nekanti only said there is no limitation under this section 5. If there is no limitation, you have to do it within a reasonable period. So they take that observation and they, while in the statement of objects and reasons, as also in the budget speech, what they say is we are fixing a timeline. Now, this is the timeline. Now what they have done, there is no limitation.
Yes.
At para 7 months. This is a strange provision. Prima facie provision appears to command the corporation to refuse to refund the amount illegally collected despite orders of this court and the High Court. The state of Gujarat was not well advised in introducing this provision. The provision attempts to make a direct inroad into the judicial powers of the state. Legislatures under our constitution can, within the prescribed limits, powers to make laws prospectively as well as retrospectively. By exercising of those powers, legislature can remove the basis of a judgment rendered by a competent court, thereby rendering that decision ineffective. But no legislature in this country has power to ask the instrumentalities of the state to disobey or disregard the decisions given by those courts. Limits of the powers of legislature to interfere with the directions issued by courts are considered by several decisions of this court. Then Prithvi Cotton Mill is, my lords, referred to. Then, my lords, Mahal Chand Sethia is referred to at page 109. There, my lords, their lordships observe about the competence and also, my lords, any amendment should be, my lords, within the subject to provisions of part 3. Part 3, why I am referring again and again is, my lords, now to show that it is manifestly arbitrary. Earlier, my lord, this subject to correction, this was under Schedule 9. The act was posted, my lords, included in Schedule 9 of the Constitution. So at that point of time, my lords, when the law was then, that you could not even test it on the violation of fundamental rights if it's included in Schedule 9. But later, the Supreme Court came out that the judgments to say even acts included in Schedule 9 can be tested on the anvil of arbitrariness. That's how now, my lords, the amendment can be tested on the anvil of arbitrariness. If I fail in everything, whether it is manifestly arbitrary is the issue. I am only going into that ground, my lords, even though.
Yes.
That's how, my lords, this judgment has gone into that issue. There are other 3 judgments, my lords, which goes into this issue. Almost on same lines. So far as arbitrariness, my lords, I will take your lordships through other things. But my lords, on arbitrariness, though I have referred at para 9 in my written submissions. Para 7, I have said if it says interpretation, it should be otherwise. Para 6, your lordship may kindly come at page 6, my lords.
Yes.
That it is not the case of state that NECNT has not declared a correct position of law, but the state has proceeded to amend the provision without removing the foundation, which is that the period of limitation to initiate proceedings under Section 5 of PTCL Act is not provided. Thus, even in the alternative, assuming for a moment that amendment is valid, it still does not remove the foundation of law laid down by the Honorable Supreme Court as regards initiation of the proceedings within a reasonable period of time where no limitation is prescribed. That's the one which I'm trying. Then law can be declared valid if it is found to have transgressed the constitutional limitations. It is open to legislature within certain limits to amend the provisions of the Act retrospectively and to declare what the law shall be deemed to have been. But it is not open to the legislature to say the interpretation of the law shall be otherwise than as declared by the court. Then, my lord, of course, at para 9 about the arbitrariness. Para 9 at page 7 minutes.
Yes.
Impugned amendment is violative of Article 14 of the Constitution and is manifestly arbitrary and discriminatory. The provision is capricious, irrational, and without adequate determining principle, as also being excessive and disproportionate by providing a non-obstante clause to the effect that notwithstanding anything in any law, there shall be no limitation of time to invoke the provisions of this Act. Judicial review will extend to scrutinizing whether the law is manifestly arbitrary in its encroachment of fundamental liberties and offends the right to equality since it discriminates against a group or community of citizens. On that, my lords, of course, there are several other judgments, but here these two judgments which we have not put here consciously, because, my lords, if I put that, your lordships will say there would have been another third volume. That, my lords, Navtesh Singh Johar, my lords, runs into almost 2 SEC books. So I have only given the para numbers, my lords, to say. But there are several line of judgments which I can produce, my lord, which are shorter judgment, which says now constitutional validity can be tested on the ground of being manifestly arbitrary. On those grounds, I will develop, my lords. Lords, I will request, I will develop on those lines. If your lordships can, my lords, now give me some time to further, my lords.
Time in
ಅಲ್ಲ ಇದು ಏನಾಯ್ತು ಅಂದ್ರೆ ಇಷ್ಟಕ್ಕೆ ರೆಡಿ ಆಗಿದ್ದೀನಿ. ಟು ಬಿ ಆನೆಸ್ಟ್, my lords, I didn't
ಬರೀ
know.
ಅರ್ಧ ಗಂಟೆಗೆ ರೆಡಿ ಆಗಿದ್ರ ಅಷ್ಟೇ.
ಇದು ಫುಲ್ಲು ರೆಡಿ ಇರ್ಲಿಲ್ಲ, ಯಾಕಂದ್ರೆ 26ಕ್ಕೆ ತಗೊಂತಾರ ಸರ್ ಅಂತಾನೆ ಅವ್ರೆಲ್ಲರೂ ಹೇಳಿದ್ದು.
26 ಫಾರ್ ದಿ AG.
Unfortunately,
19 to 26. ನಿಮ್ದೆಲ್ಲ ಇವತ್ತು ಮುಗಿಬೇಕು ಅಂತ.
Let others start, my lord. I'll only continue and bring about a few judgments I want to place on.
Everybody is depending on you.
I understand. ನನ್ ಮಿಸ್ಟೇಕ್ ಆಗಿದೆ ಇವತ್ತು, ನನ್ನ ಟರ್ನ್ ಅಲ್ಲ ಅನ್ಕೊಂಡು ನಾನು ಸ್ವಲ್ಪ ಕ್ಯಾಶುವಲ್ ಆಗಿ ತಗೊಂಡಿದ್ದು. My mistake, my lord.
Who else is ready to address argument?
They can. I'll only develop on these lines only.
He's covered everything annangilla.
Manifestly arbitrariness, I want to, my lords, just show whether it is by saying that limitation, no limitation at all, whether that amounts. No doubt it is a beneficial legislation, but can it be extended to such a limit that there is no
limitation? Is it a timeline?
Is it a timeline at all? Because it's infinite. That's not a timeline at all.
Is your contention?
I am not only, I am sure the state also will have to only agree because there is no limitation, it's infinite. They have not even brought in, my lords, they could have brought in a safeguard. That is also not brought. They have simply said there is no limitation. If there is no limitation, my lords, I am only saying it should be within a reasonable period. Now you're taking it away. You're now allowing someone to reopen after 200 years or 100 years.
100 years ella illa.
One of the now which case we have 1940 is the mortgage. This case itself.
100 agilla.
2020 they start the proceedings. 80 years. 1940 ಇಂದ ಶುರು ಆಗಿರೋದು 1930 1940. Now, my lord, 2005, they start the proceeding. Now, my lords,
Anybody else ready for the petitioners?
ಇದು ನಿಮ್ದಲ್ವಾ? Sorry.
So you have to come this side, not this side.
Oh, he'll be defending the amendment.
You're sitting on the wrong side. There are some petitions by the grantees, some petitions by the
Grantees.
purchasers. All the grantees and the state will come this side, all the purchasers will come this side. You will be in after that.
I will just continue, my lord. I need some time because I not so well. I'm sorry.
2:30 ga illa
2:30 ಇನ್ನೊಂದು ಕೇಸ್ ಇದೆ ಆಗ್ಲೇ.
ನಮ್ದು ಇದು ಬರೀ, that is why we are coming down hard on this. Bari
If
Friday we take it.
Probably, my lords, if the state had handed over on counter, at least I would have become a little more.
That's why we said you already started, let us continue, because now if we take up the other matters, all of them will get adjourned.
Please, my lord.
Because this is the issue of retrospective. And we have to apply clause D. If we have to apply clause D, none of the matters can be taken until we decide on this.
On this. Absolutely. Lord, I can.
Our problem.
Can be taken as part heard.
It
ಅಲ್ಲ,
is
parted ಅಂತಾನೆ ಇದೆ.
parted. You're complete heard ಮಾಡ್ಬೇಕು ಅಂತ ಅಷ್ಟೇ.
Subject to my lord's convenience, if they are going to give us in a day or two, my lords, probably during
Giving
the
it
course of
tomorrow,
next.
we'll have it on Tuesday.
Yes, ma'am.
Tuesday at
That's right.
2:30 we'll have it.
ಅವರು ಒಂದ್ ಅಡ್ವಾನ್ಸ್ ಕಾಪಿ ಕೊಟ್ಬಿಡ್ಲಿ, ಅಲ್ಲಿ ಇಲ್ಲಿ ಬಂದ್ ಕೊಡೋದ್ ಬೇಡ ಅಂತ ಅಷ್ಟೇ. ರೆಡಿ ಇದ್ರೆ ಓನ್ಲಿ ಸೇ
ಏನ್ ಹೇಳ್ತಾರೆ ನಿಮ್ಗೂ ಗೊತ್ತು.
ನನ್ಗೆ ಗೊತ್ತು.
ಇನ್ ಏನಿದೆ ಅದ್ರಲ್ಲಿ, ನೀವೇನ್ ಹೇಳ್ತೀರಾ ಅಂತ ಅವ್ರಿಗೂ ಗೊತ್ತು.
Yes, my lord.
ನಾವು ಕೇಳ್ಬೇಕಷ್ಟೇ.
My lords, I will just do some. Tuesday ಇಟ್ಕೊಂಡ್ರೆ we'll complete.
Heard for the
I'm
argument.
sorry,
of
my lords.
Ken Panindra, learned senior counsel
ಇನ್ನೊಂದು
in part for his further arguments released on Tuesday at 2:30.
Please.
Filing statement up to Tuesday can be.
Tuesday ಅಲ್ಲ, ನಾಳೆ ನೀವ್ ಹೇಳಿದೀರಾ.
Tomorrow will.
ನಾಳೆ ಫೈಲ್ ಮಾಡಿ ಅವ್ರಿಗೆ ಕೊಡಿ.
Please, ma'am.
ನಿಮ್ ಟೈಮ್ ಕೊಡ್ತಾ ಹೋದ್ರೆ ನೀವ್ ಹಾಕಲ್ಲ.
My lord.
3 ಸತಿ ಕೊಟ್ಟಾಗಿದೆ, ಹಾಕಿಲ್ಲ
My
ನೀವು.
lord, everything is ready. My government approval, my lord, but is we are waiting.
That is the same submission you have been
Yes,
making
my
for the
lord,
last
but-
4 weeks, madam.
Please, my lord. Yes.
Now we won't
We
listen to that.
apologize, my lord, but
We heard you, we gave you 4 times adjournment on that.
ಇನ್ನೂ ರಿಸರ್ಚ್
It cannot be a practice. Sometime we'll have to put an end.
please, please, ma'am. How-
Yes. ಅವ್ರಿಗೊಂದು ಕಾಪಿ ಕೊಟ್ಬಿಡಿ, Mr. Panindra. Mr. Ramesh, since it is a lead matter, he is also the respondent.
Sir. Panindra.
ನೀವೇನಾದ್ರು ಫೈಲ್ ಮಾಡಿದೀರಾ?
Nandi validity illa. Mine is, as he said, it's a case of a mortgage.
So who is leading the matter on this side?
I think it's the state.
Apart from the state, anybody else?
My friend who just now said he appears to the petition. Mine is a more a factual.
Clifton, you are filing any submissions? Next date is Tuesday, so before that you serve it. So who is leading it on this side?
AG.
Apart from AG? ಇನ್ಯಾರು ಇದಾರ? For the grantee? You are supporting the legislation, so you are also on this side. So you are filing anything? Whatever you are filing, please serve it on Mr. Panindra.
Done.
Tuesday, 2:30.
Interim order may be stayed.
Interim order earlier granted is extension. Argument ಮಾಡ್ತೀರಾ?
ಎರಡು ಕಾಪಿ ಬೇಕಿತ್ತು, ಒಂದೇ ಕೊಟ್ಟಿದ್ದೀರಾ. Please, ಒಂದೊಂದು. For dismissal, serial number 31. ಇದೆಲ್ಲ ವಿವೇಕಾನಂದ ನಾನೇ
Yes, Mr. Reddy. ಏನಕ್ಕೆ?
ಅದೆಲ್ಲ ಅದೆಲ್ಲ ನಿಮ್ಗೆ.
ಅದೇ ಇವಾಗ ಎಲ್ಲ ಭಜನೆ ಆಗ. The net counsel for the petitioner seeks fund is granted a week's time to file
ಯಾರ್ದಿದೆ madam?
an application to challenge the amendment to section 5C and 5D.
ಯಾವ್ದು?
May I submit that in this case that may not be applicable at all, because what they have said is that it is self-acquired property and not a grant.
ಸರಿ.
The DC has observed that the grant certificate was in fact produced before the AC, but not looked into by him. And on that basis, it has been set aside. It has nothing to do with limitation and things.
When was the sale?
2009. 2009.
2009. And when did you challenge? 5 years is within reasonable period of time. Then the amendment may not apply. Because even if we were to hold, Nikanti would apply unreasonable, 5 years would be reasonable. 2009 sale. But anyway, we still have to come to a conclusion whether ಯಾವುದು ನಡೆಯಲ್ಲ. That's the problem with this. Until this issue is resolved, this whole roster is virtually.
It's throttled.
My lord, it is,
Until that we can't
this
do anything.
petition, my lord, it is after the act, my lord, 2019 sale, my lord. It is in violation of.
permission.
Please, my lord.
6 point is granted a week's time to file application to challenge the amendment to section 5C. Relist on 26th.
Serial number 32. Sri Hari AV.
Grantees petition. That
relying upon the decision of certain minutes, certain versus permission. Order saying that.
when did you file the presumption? Sale is in 81. Again, we'll have to say decide. BN Prakash, who has filed caveat for respond number 4, accepts notice for respond number 4.
4 and
And
5.
ATA accepts notice for respond number 1 to 3. What about 5?
4 and 5, I have filed a caveat.
4 and 5, accepts notice for 4 and 5.
Because they are the vendors. 4 and 5.
Second purchaser.
Second.
Memo. Counsel for the petitioner has filed a memo seeking for dispensatory notice to respond number 6 and 7 on the ground that respond number 6 and 7 were the first purchasers who have sold it to respond number 4 and 5, and that they would not be affected by any order passed by this court. Accepting his submission, notice to respond number 6 and 7 is dispensed with. Relist on 26th.
Yes.
Serial number 33.
Petitioner.
Grantee. And 33.1, no?
We are the petitioners in that case.
You are also a grantee.
I'm not the, yes, ma'am.
You sold it. So both of you have challenged the same order. So you wanted to yourself, it has been restored to the government. Now, delay issue ಏನಾದ್ರು ಇದೆಯಾ?
My lord, there's a 19 years delay there.
Sale?
They have filed a restoration after 19 years.
So ನಿಮ್ದ್ರಲ್ಲಿ ಚಾಲೆಂಜ್ ಮಾಡಿದೀರಾ?
Yes, my lord, we have challenged.
Amendment ಚಾಲೆಂಜ್ ಮಾಡಿದೀರಾ?
Yes, ma'am. My lord, in their case, notice has not been ordered, my lord.
ಎಲ್ಲರೂ 33. You accept notice for 1 and 2, na?
Yes, ma'am.
The KV Narasimhan accepts notice for respond number 1 and 2. Third, HCGP accepts notice for respond number 3 to 5. ಇದರಲ್ಲಿ ಆಗಿದೆಯಾ 33.1 ಅಲ್ಲಿ 33.1 Mr. Somshekhar Kashimath accepts notice for respond number 3. Respond number 3. Relist on 26th. Both the grantee and the purchaser are restrained from any manner dealing with, alienating, encumbering the property subject matter of the above petitions till the next date of hearing.
Serial number 34.
What is this note?
Nimde, 34 Nimde.
ನೀವ್ ಯಾರಿಗೆ? Have you challenged the section 5C? Challenge ಮಾಡಿ. ಕೊಡಿ. 14221 connect with WP 14221 of 2024. ಕೊಡಿ. And SCGP accepts notice for respond number 1 and 2. And now notice order ಮಾಡಿಲ್ಲ ನೀವು ಸರ್ವ್ ಮಾಡಿದ್ರೆ ಹೆಂಗ್? Mr. Narsimurthy and Kalyan R. ಯಾರು ಅಪಿಯರ್ ಆಗ್ತಾ ಇದ್ದಾರೆ ಇವಾಗ? ಕಲ್ಯಾಣ್ ವಕಾಲತ್ ಫೈಲ್ ಮಾಡಿದಾರ?
Not filed.
ಯಾರಿಗೆ? ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ವಾ? ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ವಲ್ಲ ನೀವು? 5C ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ಲ. ಇವಾಗ ಮಾಡಿದೀನಿ ಅಂತ ಹೇಳಿದ್ರಿ. ಮಾಡ್ಬೇಕಲ್ಲ. If we come to a conclusion that it's not grow more, then you want to take a risk. Problem neither you can take the risk, nor we can take the risk on that. You have to challenge it. 3 and 4 Kalyan ಆಗಿದಾರಲ್ಲ.
Kalyan or Vakalat files.
Shri Kalyan R has filed Vakalat number for respond number 3 and 4. Has delete the name of Shri Narsimurthy N as that are paying for respond number 3. 6 and 7 arrow. 5, 6 and 7. Issue notice to 5, 6 and 7 returnable by 27th September. The operation of the order dated so and so at annexure A is stayed till the next date of hearing. Both the petitioner and respond number 3 to 7 are restrained from in any manner dealing with, alienating or encumbering the property subject matter of the above petition till the next date of hearing. Process fee and copies to be furnished by end of day 24th July, failing which the interim order will stand automatically vacated.
Serial number 35. CEO Kerala.
Appear for the respond number 5 and 11, my lord.
5 and 11, yes. Grantina purchaser. SCGP accepts notice for respond number 1 and 2. Shri R. Shivacharan, who has filed caveat for respond number 5 and 11, accepts notice for respond number 5 and 11. Please, what about others?
Notice has to go, my lord.
You accept madalva?
My lord, I'll just verify, my lord, in case that is so.
5 is son of Machaya.
Yes, my lord.
Bakino ella son
As
of
on today, my lord,
Machaya.
I have not given any instruction. Anyway, my lord, I'll verify. If so, my lord, I'll file Vakalatnama immediately.
Issue notice to respond number 3, 4, 6 to 10 and 12, returnable by 27th September. The operation of the order dated 26/3/24 at annexure
A, my lord.
A is stayed till the next date of hearing. Both the petitioner and respond number 3 to 12 are restrained from any manner alienating, dealing with, encumbering the.
In fact, we are in the position, my lord.
Don't alienate.
Yes, sir.
Construction ಬೇಡ ಅಂತ ಹೇಳ್ಬೇಕಾಗತ್ತೆ ಅಷ್ಟೇ.
ಇಲ್ಲ, my lord, it's a vacant land. ಇಲ್ಲ, that has been demolished. Subsequent to the, my lord, one
Alienating
petition.
and encumbering the property subject matter of the above petition
Please.
till the next date of hearing.
Yes.
Process fee and copies to be furnished by end of day 24th, failing which the interim order will stand automatically. That it's converted.
We are disputing the very conversion, my lord. We are disputing. If that is, Lordship may
Conversion order is there.
Lordship may kindly see one paragraph.
Then AGA is, SCGP is directed to secure information as to whether the property has been converted or not.
We are questioning the transaction, my lord, itself, my lord. Because there was a bar when the grant certificate is issued, my lord. Lordship may kindly see annexure
If it has
A.
been converted prior to the sale, The judgments of this court
Please.
say otherwise. You may have a good case on everything else, but on that you will fail under Voitu.
ಅಲ್ಲ ಮೇಡಮ್ ಏನಾಗಿದೆ at the time of my lord issuance of the certificate, there was a order passed by the state government saying that for the period from 1938 to 1953, ಯಾವುದು ಇದಾಗಿದೆ, there should not be alienation itself.
ಇರಬಹುದಪ್ಪ, but conversion ಆದ್ರೆ that has been dealt with by a coordinate bench.
Please, yes, I'll,
That judgment is what will apply to you.
please, ma'am.
After service, it will apply.
Yes.
36.
Appeal for the petitioner, my lord.
Yes.
My lord, purchaser's petition, my lord. 67 was the first sale, my lord. Application filed in 83.
The 5C challenge ಮಾಡಿ.
Oh, Martin, sir.
Yeah, I learned SCGP accepts notice for respondent number 1, 2, 3, issue notice to respondent number 4, written by 27 September. The operation of annexure D and K stayed till the next date of hearing. Process fee and copies to be furnished by end of day 24th, failing which entry model will stand automatically vacated.
37.
Hmm. 68 sale ಆಗಿ second challenge. Learned SCGP accepts notice for respondent number 1 and 2, issue notice to respondent number 3 to 4, written out by 27 September. The operation of the order dated so and so at annexure A is stated. Process fee by 24.
38.
Yes. Purchaser.
No documents produced.
Hmm. So you're disputing the grant. There's no issue about time. And SCGP accepts notice for respondent number 1 and 2, issue notice to respondent number 3 to 5, written out by 27th. The operation of annexure A and B is stayed till the next date of hearing. Both the petitioner and respondent number 3 to 5 are restrained from any manner dealing with, alienating or encumbering the property subject matter of the above petition. Process fee by 24th, failing which. Yes.
Serial number 39 to 41 adjourned. 42. MS Varadarajan.
Varadarajan.
Appeal for the respondent.
ಈ ಕಡೆ ಬರಕ್ ಬದಲು ಆ ಕಡೆ ಹೋಗ್ತಾ ಇದ್ದಾರೆ. Mr. Muniappa, you are appearing for respondent number 6. 5. 6 ಇದೆ. L Mahesh for 7, MD Anuradha for 8. Where are the others?
I
Mr.
appeal for
Prakash?
8th respondent.
Yes. Mr. Prakash Hegde,
No, I appear for him.
you appear for him. So 4, 5 and 6 you are appearing.
Yes.
What about 7? L Mahesh,
7 and 8 I appeal.
you appear. So everybody is here. Ready? Hmm.
Just explain the facts, report to the proceedings.
ಅಲ್ಲ, you want time ಅಂದ್ರೆ we'll give you time. Otherwise start ಮಾಡಿದ್ಮೇಲೆ you are the purchaser. Any time.
Purchase the land, the matter has become final. That I should have redated the liquidation and amended the liquidation by adding.
Any issue on delay and limitation?
Nothing. That has been settled in the, in fact, this court at least allowed the liquidation on the ground of delay.
Hmm.
Division bench said there is no delay and remanded the matter. That question is not available, that argument is not available to me.
Learned counsel for the petitioner seeks for and is granted 2 weeks time to get ready and address argument released on 2nd August.
43. Vishwanath R. Hegde.
Present R5, statement of objections, Lord, I have filed.
Ah.
Page number 76, the office said it is not clear. Lord, I am not relying upon that, page 76.
Learned counsel for respondent number 5 submits that he would not rely on page 76 of his
Yes.
statement of objection. ಅದೊಂದೇನು objection?
Copy not
ಅದೊಂದು-
served to petitioner.
Copy?
ಕೊಟ್ಟಾಯ್ತು ಅವಾಗಲೇ ಕೊಟ್ಬಿಟ್ಟಿದೆ ಲಾಂಗ್ ಬ್ಯಾಕ್.
Further submit that copy of the petition has been served on the counsel for the petitioner. In view of the said submission, office objection are overruled. None appears for the petitioner today. If none were to appear for the petitioner on the next date of hearing, petition would be liable to dismiss for non-prosecution released on 2nd August.
Obliged. Great.
44, Nagaraj RC.
I pay for respondent for my lord in this case. My lord, when I made an inquiry, my lord, the respondent for my lord, she passed away. She died on my lord 25/1/2023. I'm reporting my lord the
2016,
death of respondent for. I pray for an accommodation to my lord file necessary application to bring legal aids on record.
You will
Right
file.
to sue survives me.
Counsel for respond number 4 submits that respond number 4 is expired
On 25/1/23.
on
25/1/2023.
25/1/2023. He seeks for a short accommodation to file necessary application to bring the legal representative to
Yes, sir.
respond number 4 on record. Relist on
2 weeks time, bro. They resides in Ooty.
2nd August.
Yes, please.
ಅಷ್ಟೊಳಗೆ ಆಗತ್ತಾ ಇಲ್ಲ ಇನ್ನೊಂದು ವಾರ ಬೇಕಾ?
ಇನ್ನೊಂದು ವಾರ ಕೊಟ್ಟು
9th August.
ಅಲ್ಲಿ ಮಾಡ್ತಾರೆ.
He cannot
ಇಲ್ಲೇ
appear
ಇಲ್ಲ
for
ಅವ್ರು.
anybody.
She is not there.
We can't direct him.
Please.
He doesn't appear. Mr. Hegde,
I have just one, there is some problem with my vehicle. There is
ಅದರಲ್ಲಿ 43 ಅಲ್ಲಿ none appears ತೆಗೆದುಬಿಡಿ.
this,
Relist on 2nd August.
this, there was a direction to secure the records my lord, by the government advocate.
ಬಂದಿದ್ಯಾ? Learned HCGP submit, AG submit that the records have been secured.
Please.
Both the counsel for the petitioner and respond number 5 are permitted to take inspection of the.
I am obliged my lord. I am grateful.
My lord, today at
45.
today at 1:30, my lord, if they verify, I have to send it back, my lord, again.
Mr. Hegde, lunchtime.
Please my lord, I will come my lord. I will come by 2.
ಇವತ್ತೇ lunchtime.
Please,
Please.
grateful.
45,
Lord, I pay for respondent number 3 million. And I
Yes.
need to file objections, my lord. That amendment also. And earlier also I could not file the objections.
ಏನ್ amendment?
ಅದೇ
5C ಚಾಲೆಂಜ್ ಮಾಡಿದಿರಾ?
ಅಲ್ಲ, ಓವರ್ ಆಲ್ ಪಿಟಿಷನ್ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕ್ಲಿಲ್ಲ. That's ಸರಿ.
ಹಾಕಿಲ್ಲ. ಯಾವಾಗ ಆಗ್ತದೆ?
2 weeks ಅಲ್ಲಿ ಆಗ್ತದೆ.
Counsel for respond number 3 seeks for and is granted 2 weeks time to file his objections to the main as also to the amended petition. Objections, if any, to be filed on or before 6th August, relist on 9th August.
Please.
Interim order earlier granted is extended till next.
46, R Gopal.
This case, my lord, I filed the NOC wakalat yesterday, my lord.
ಯಾರಿಗೆ?
6 to weeks time.
For respond number 3 to 5.
Yes, my lord.
PN Harish submits that he has filed wakalatnama yesterday for respond number 3 to 5. He seeks for and is granted 2 weeks time to get ready and address his arguments. ಏನಿದ್ರಲ್ಲಿ delay issue ಏನಾದ್ರು ಇದೆಯಾ? Second application. Again, challenge. Relist on 9th August.
Please.
16th August.
16th.
16th Rajana. 15th Rajana.
Plus
16th
16th.
Rajana.
16th Rajat.
ಗೊತ್ತಿಲ್ಲ ನೆಕ್ಸ್ಟ್ ಬೆಂಚ್ ಏನ್ ಮಾಡ್ತಾರೆ ಅಂತ ಯಾವತ್ತು ಹಾಕೊಂತಾರೆ ಅಂತ ಗೊತ್ತಿಲ್ಲ. ವಿ ಆರ್ ಸ್ಟಿಲ್ ಗಿವಿಂಗ್ ಇಟ್ ಸ್ಯಾಟರ್ಡೇ ಫ್ರೈಡೇ ಓನ್ಲಿ.
Hope so.
23rd August.
Please.
16th ರಜಾನ. 24th Saturday ಆಗತ್ತೆ. We are giving it on Friday, thinking probably the next bench may also continue with that. And we don't know. Change ಮಾಡಿದ್ರೆ ಅವ್ರು ಮಾಡಿ.
Please.
47, G Manivannan.
Purchase of petition.
ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡಿದ್ದೀರಾ? ರೆಕಾರ್ಡ್ಸ್ ಬಂತ ಮೇಡಮ್?
47, yes, my lord, we have received.
Then AGS submit that records have been received. Counsel for the petitioner and respond number 3 are permitted to take an inspection
Please, my lord.
of the said records. Relist on 9th August.
Great.
Hmm. 20th, 30th, 46th, 30th.
48, Rajendra MS.
Respond 4 to 7 minutes. I will seek for short accommodation.
In delay issue ಏನಾದ್ರು ಇದೆಯಾ ಇದರಲ್ಲಿ? ನೀವ್ ಯಾರಿಗೆ? ಗ್ರಾಂಟಿನ? Grantees petition. You want to file your objections?
Yes, ma'am.
Counsel for respondent number 4A to C, 5 and 7 seeks for and is granted 2 weeks time to file a statement of objection. Objections, if any, by 6th, relist on 9th.
Obliged.
49, M.E. Maheshwarappa.
Counsel for the petitioner seeks for and is granted. ಅಲ್ಲ ಎಷ್ಟು ದಿನ ಬೇಕು ಟೈಮ್ ಆಗಿದೆಯಾ ಮತ್ತೇನು ರೆಡಿ ಇತ್ತಾನೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಸೊ 26th 49 connect with
That's 30.
Serial number 30.
30 and relist on 25th.
50. Hari Prasad MD.
State has to file objection. There is no other private respondent.
Grantees.
ಯಾರು ಇಲ್ವಾ?
They are the grantees, my lord.
Purchaser ಯಾರು ಇಲ್ವಾ? The only state is shown as 1 to 5. Why have we not made them here?
They have to make the.
Yes. So when is that matter posted now? 50, connect with WP number so and so and relist on so and so date. Yes,
Grantee petition.
both of them will
Yes, please, ma'am.
have to be heard together.
51. Kumara.
Not appearing for the respondent. Malak, this is a matter where the constitution validity has been challenged.
Hmm.
He had submitted that we would be.
Connect with 30 and relist on 26th.
Yes.
Serial number 52 Arjun. 53.
Petition, immediate man. After 19 months was before Manada. For pending consideration application, completely after 2 weeks.
Comply ಮಾಡಿದೀರಾ? ಆಗಿದೆಯಾ?
Complete.
Learned counsel for the petitioner is complied with the office objection. ಆಮೇಲೆ
Notice.
ಏನ್ ಡಿಸ್ಮಿಸ್ ಏನಾರು ಆಗಿತ್ತ? ಮತ್ತೆ ಕಾಸ್ಟ್ ಏನಿದೆ? Restore ಮಾಡಿದ್ದಾರೆ 2000 ಕಾಸ್ಟ್ ಹಾಕಿದ್ದಾರೆ on 5/2/24. ಪೇಮೆಂಟ್ ಮಾಡಿಲ್ವಾ? ಆರ್ಡರ್ ಇದೆ. ಯಾಕೆ ಆರ್ಡರ್ ಅಪ್ಲೋಡ್ ಆಗಿಲ್ವಾ? Learned counsel for the petitioner submits that since the order dated 5/2/24 had not been uploaded, he was not aware of the imposition of cost. The Registrar Computers is directed to look into the matter and verify as to why the order has not been uploaded and to issue necessary instructions for all daily orders to be uploaded onto the website. Counsel for the petitioner seeks for and is granted a week's time to make payment of the cost. Relist on 26th. You have cost ಕೊಡೋವರೆಗೂ it's a conditional order. ಕೊಡಿ, next 26th will restore it, we'll take the cost and issue notice.
54. Srikanth MP.
R4 and 5 stand dismissed. ಇನ್ನೇನು ಉಳಿಯುತ್ತೆ? ಇನ್ನೇನು ಉಳಿಯಿತು? ಫೈಲ್ ಮಾಡಿದ್ದೀರಾ? ಇದೆಯಾ?
Today it is.
ಪಾಸು. ಈಗ
55. Madhukar Nadi.
ಪಾಸು.
56. Poonam Patil.
Hearing correspondent.
Ready?
Password.
ಪಾಸು. Ready?
57. Narendra Gowda.
ಏನು ಗ್ರಾಂಟಿನ ಏನೋ ಗೊತ್ತಿಲ್ವಾ? ಏನೋ ಗೊತ್ತಿಲ್ಲ. 57 at the request of counsel for the petition released on 9th.
58, Prasanna VR.
Grantina purchaser.
For mutation. The mutation proceedings not rejects the mutation, saying that not the one of the fifth respondent has filed an objection, stating that it was a granted land. As a matter of fact, it was not a granted land, which is in the meaning of the CH-15 Act. But it was a granted land in favor of the sixth respondent who was an exception.
So you are ready. Where's Mr. Naveen? Password or number idea? Phone number idea? ಮಾತ್ರ ಯಾರ ನಂಬರನು ಇಲ್ಲ ಅಂತೀರಾ ನೀವು? ಎಲ್ಲ ನಂಬರ್ ಇಟ್ಕೊಳ್ಬೇಕು ನೀವು. ಅಡ್ವೊಕೇಟ್ ರಿಜಿಸ್ಟ್ರೇಷನ್ ಮಾಡಿದೀರಾ? ಅದ್ರಲ್ಲಿ ನೋಡಿ, ಇದರಲ್ಲಿ ನಂಬರ್ ತಗೊಳ್ಳಿ, ಪಾಸ್ವರ್ಡ್.
9900 177 656 59
Respond number 3 in this.
Harish. Ready? Password.
Not said directed for records.
ಬಂದಿದ್ಯಾ?
Telephonically, I have communicated them.
59 learned SCGP submit that the records are yet to be secured.
Please.
She seeks for 2 weeks time, 3 weeks time to secure the same. Released on 9th August. If records are not secured by then, the jurisdiction Tahsildar shall remain personally present before this court.
Serial number 60, urgent 61. Srikanth NV.
I appear for respond number 3, my lord. Raise time to file an objection, my lord.
In delay issue ಏನಾದ್ರು ಇದೆಯಾ?
Delay.
Counsel for respond number
3.
3 seeks for and is granted 2 weeks time to file is statement of objections released on 9th August.
Serial number 62.
Interim order earlier granted is extended. 62.
Chandrasekhar C.
Password. That's 213.
Past door matters. Serial number 4. SV Prakash.
Ready and password.
Serial number 8. INR.
ಏನಿದು? ಬಂತ?
ಇಲ್ಲ.
ಬಂದೆ. Password ಭರತ್.
Serial number 10. PM Siddhappa.
None appears for the petitioner, though called twice. 2 weeks time is granted to the petitioner to file necessary application for challenging the amendment to section 5C. Released on 9th August.
12. Gautam Mayor.
Same order.
15. Gopalakrishna Murthy.
Pitching aita. IA 1 of 24 had been filed, challenging 5C allowed. Counsel for the petitioner to carry out necessary amendment, file amended petition. Released on 26th. Connect with 30.
Serial number 17. Abhina guess. Number.
Mr. Nadig. Land Council for respond number 4 to 7. Submit that you will be filing is counted today. After service of serving a copy thereof on the council for the petitioner. None appears for the petitioner today. Relist on 9th August.
56,
Pass over.
58, Prasanna VR,
Pass over.
62,
Pass.
May I make one request, all disposed of matters, we are not getting orders, daily orders. Daily orders ಬರ್ತಾ ಇಲ್ಲ ಯಾವ?
Daily orders ಬರ್ತಾ ಇಲ್ಲ.
No, my lord. 1 month back, Raj Kalve matter, without daily order, my lord, complaints ಮಾಡ್ಲಿಕ್ಕೆ ಆಗದೇ ಇಲ್ಲ.
Number ಕೊಡಿ ಅದು.
I have given court officer ಕೊಟ್ಟಿದ್ದೀನಿ. Given.
ಬರ್ತೀರಾ ಆಮೇಲೆ? ಮತ್ತೆ ಕೇಳಿ.
ಎಲ್ಲ ಸೈನ್ ಆಗಿದೆ.
No, my lord. Almost all disposed of matters.
The order sheets only of yesterday and day before. Disposed or daily order?
Disposed of only daily orders.
ಅದು ಎಲ್ಲ ಸೈನ್ ಆಗಿದೆ.
No.
Only yesterday and day before is not been signed.
Last 1 month, June we have not yet got.
Upload ಆಗಿಲ್ಲ.
It is here.
ಏನು uploading?
It is here. I think it is here.
Upload ಏನೋ ಪ್ರಾಬ್ಲಮ್ ಆಗ್ತಾ ಇದೆ. We'll verify.
More specifically, BBMP matters. ಯಾವುದು
There seems to be
Because
some
they
issue
have
of
been
some
calling-
exposed matters ಅಲ್ಲಿ upload ಆಗ್ತಾ ಇಲ್ಲ. We'll
Yes, ma'am.
check with the register computers
Please,
and get.
please, obliged.
Serial number? ಆನಂದ್ ಸಿಕ್ಕಿಲ್ವಾ? ಫೋನಲ್ಲೂ ಸಿಕ್ಕಿಲ್ವಾ? Though counsel for the petitioner is present and ready to address arguments, none appears for respond number 4 to 8. Relist on 9th August.
But in serial number 17, my lords, we are unable to contact the respondent number 7 and 8.
ಮತ್ತೆ ಅರ್ಜೆನ್ಸಿ ಹೆಂಗ್ ಮಾಡಕ್ಕಾಗತ್ತಪ್ಪ?
I would only request your lordships to grant as early a date as it is permissible, my lord. I would leave it to my lords.
4 weeks at least we have to give.
Please, please, I understand, please.
ಅದು 17 already dictate ಆಗಿದೆ. Issue notice to respond number 7 and 8 returnable by. Emergent notice returnable by. ಯಾವತ್ತು?
13/9 ಆಗಿದೆ.
13/9 6th ರಜಾ ಇದೆ. 30th August.
Oblige, my lord.
Interim order earlier granted is extended till next date.
Oblige, my lord.
ಮಂಡೇ ಎಲ್ಲ ಆಗಲ್ಲ. ನೆಕ್ಸ್ಟ್ ಫ್ರೈಡೇ ಮಾತ್ರ. ಮಂಡೇ ಒಂದಿನ ಮ್ಯಾಟರ್ಸ್ ನಡೆಯುತ್ತೆ. ಫ್ರೈಡೇ ಯಾವ್ದು ನಡೀತಾ ಇಲ್ಲ. ನೋಡಿ ಎಲ್ಲ ಆಗೋಯ್ತು. ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ ಅಂದ್ರೆ ನೀವು ಮಾಡಲ್ಲ.
Now part heard, my lord, it will another 2 weeks it will be.
ನಿಮ್ದು ಅದಾಗೋವರೆಗೂ this roster cannot function.
Correct. I agree, my lord.
There's no work.
Apologies, my lord. Objections are ready, from government, my lord, they are saying every day, my lord.
58, counsel for the petitioner is present and ready to address argument. None appears for respond number 5. Relist on 9th August.
My lord, serial number 57, my lords.
57.
My lords, in this case, I'm appearing for respondent number 4, my lords.
Adjourned all.
Yes, we have adjourned it. You are for
My
whom?
lords, I'm for respondent number 4, my lords.
We observed that you are not there and adjourned it.
My lords, I was appearing through VC. Due to network issues, I was unable to connect, my lords.
57. ಅದು ನನ್ನ
My lords, ಇದರಲ್ಲಿ ಲಾಸ್ಟ್ ಟೈಮ್ ಒಂದು ಅಮೆಂಡ್ಮೆಂಟ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ರು, my lords, ಅದು ಕಾಪಿ ನಮಗ್ ಸರ್ವ್ ಆಗಿಲ್ಲ.
Then contact. ಅವ್ರು ಬಂದಾಯ್ತು, ನೀವ್ ಇರ್ಲಿಲ್ಲ ಅಂತ ಅಜ್ಜನ್ ಮಾಡಿ ಆಯ್ತು, ಅವ್ರು ಹೋಗಿ ಆಯ್ತು. So you will have to find them and get it.
My lords, my presence may be noted, my lords.
57 at the request of both the councils, relist on 9th August.
Oblige, my lords.
ಅವ್ರಿಗೊಂದ್ ಸ್ವಲ್ಪ ಆಗಿದೆ.
This one.
17. ಅವ್ರು ಮಧ್ಯಾಹ್ನ ನನ್ಗೆ
Court officer? Court officer? Court officer? ಇಲ್ಲ ಕರೆಕ್ಟ್. ಈಗ ಸಿದ್ದು ಪಾಟೀಲ್ ಸಿದ್ದು ಪಾಟೀಲ್ ಸಿದ್ದು ಪಾಟೀಲ್ ಬಂದು ಸಿದ್ದು ಪಾಟೀಲ್ ಬರ್ತಾರೆ. ನಾ ಕಳಿಸ್ತೀನಿ ಸರ್, ಸದ್ಯ ಕಳಿಸ್ತೀನಿ ಸದ್ಯ ಕಳಿಸ್ತೀನಿ. ಆರ್ತಿ ಪಾಟೀಲ್ ಇಲ್ಲ. ಹಾ ಎಲ್ಲಿ ಅದಮ್ಮ ಇದು?
ಟೇಬಲ್ಗೆ ಸರ್ ಅದು ನಿಮ್ಮ ನಿನ್ನೆ ಬಂದಾಗ ನಿನ್ನೆ ಬಂದಿಲ್ಲ ನಿಮ್ ಟೇಬಲ್ಗೆ ನೋಡಿದ್ರೆ
ಸರಿ
ಕೋರ್ಟ್ ಆಫೀಸರ್
ಸರ್ ಹೇಳಿ ಸರ್.
ಮೇಡಮ್ ಕಲಬುರ್ಗಿಯಿಂದ ಬರ್ತಾರೆ, ಕೇಳಿಸ್ತಾ?
ಕೇಳಿಸ್ತಿದೆ ಸರ್.
ಅದು ಒಂದ್ ಪೇಪರ್ ಸವಿತಾ ಮೇಡಮ್ ನಿಮಗೆ
ಸರ್ ನಿಮ್ ಜೊತೆ
ಬಂದಿದೆ ಸರ್, ಅದು ಪೇಪರ್ ಬಂದಿದೆ.
ಅದು ಕೋರ್ಟ್ ಇಂದ ಸಬ್ಮಿಟ್ ಮಾಡಿದ್ದು ಸರ್ಕ್ಯುಲರ್.
ಸಿಕ್ಕಿದೆ ಅದು.
ನೀವು
ಇಲ್ಲ ಫಸ್ಟ್ ಧಾರವಾಡ ಕಲಬುರ್ಗಿ, ಆಮೇಲೆ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್. ಅದೇ ಅದೇ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಅಲ್ಲೇ ಫಸ್ಟ್ ಒಂದು
ಗುಲ್ಬರ್ಗ ಧಾರವಾಡ ಹಳ್ಳಿ
ಧಾರವಾಡ ಫಸ್ಟ್ ಒಂದೊಂದು.
WP ನಂಬರ್ ಹೇಳಿ. ಸರ್ಚ್ WP ನಂಬರ್ ವೇರ್ ಇಟ್ ಇಸ್.
ಆರ್ತಿ ಮೇಡಮ್ ಇದು ಗುಲ್ಬರ್ಗದು ಬಂದಿದೆನಾ ಡಾಕ್ಯುಮೆಂಟ್? ಅಂದ್ರೂ ಒಂದ್ ಇಟ್ಕೊಳ್ಳಿ.
ಎರಡುನು
ಸರಿ ಎರಡು ಸ್ಟೇಟ್ಮೆಂಟ್ ರೆಡಿ ಮಾಡಿ
ಹೋಗಿದೆಯಲ್ಲ ಸರ್ ಫೈಲು. 436 15/7 ಹೋಗಿದೆ ಎರಡೂನು.
ಏನ್ ಮೇಡಮ್ ಅದು ಎಷ್ಟನೇದಿದೆ ಅದು?
ಫಸ್ಟ್ ತಗೊಳ್ತಾರೆ.
ನಾನು ನಿಲ್ಲ ಅಷ್ಟೇ. No, tell me in the list, list which serial number, which serial? ಅಲ್ಲಿ ನೋಡಿ ಆಚೆ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಬಂದಿದೆ ನಿಮ್ದು W.
ಏನು? ಅಯ್ಯೋ ನಾನು ಓಡಾಡಿ ಬಂದೆ. ಕೂತವಳೆ ಇಂದ ಹುಡುಗರು ಮಾಡೋದಿರಲ್ಲ. ಹೌದು ಅದೇ ಗೊತ್ತಾಯ್ತು. ಎಷ್ಟನೇ ಸರ್? SV ಪ್ರಕಾಶ್ ಅವರ
ಮೇಡಮ್
See the search the 42. Once again confirm. ಕಲಬುರ್ಗಿ ಅಲ್ಲಿದ್ದಾರೆ. ಆಯ್ತು ಹಂಗೆ ಮಾಡಿ ಸರ್, ಇರುತ್ತೆ ಎಲ್ಲ ಬಟ್ ಕೋರ್ಟಿಗೆ ಮೆನ್ಷನ್ ಮಾಡಿ ಮೇಡಮ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ. ನನಗೆ ರೆಕಾರ್ಡ್ಸ್
Dharwad bench matter.
Oh, okay. I submitted that the bereavement in the family of the counsel for the petitioner. Relist on yeah, this second,
The 6
6th
into 4
August, 6th August.
Kalburgi bench matter.
Sorry, my lords.
Yes.
Sorry, my lords. The Dharwad bench, my lords. Only one
Ah.
matter is there, my lords.
Dharwad bench Sadiq or not well and sorry, our mother-in-law expire adrante.
Please,
6th August.
Please, my lords, please.
Report banta.
Malad.
Yes.
Maladship, in this case, Malad, the concerned police department has issued the circular by the government of Karnataka, and page number 4 is the circular, Malad. Page number 4, Director of the General Police Inspectors of the Police Kachari, 7/5/2024, man. Sutole.
ಬರೀ ಖಂಡಿಕೆ 53 ಅಂತ ಹೇಳ್ಬಿಟ್ರೆ ಆಗಲ್ಲ. You will have to guide
Malad,
them as to what they have to do.
Subsequently, Malad, page number 3, 9/5/2024. So that the subject ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯ ಕಲಬುರಗಿ ಬೆಂಚ್ so and so ಪ್ರಕರಣದಲ್ಲಿ ಕೆಳಗಡೆ ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯ ಕಲಬುರಗಿ ಪೀಠ ಇಲ್ಲಿ ದಾಖಲಾಗಿರುವ ರಿಟ್ ಅರ್ಜಿ ಸಂಖ್ಯೆ ಪ್ರಕರಣದಲ್ಲಿ ನೀಡಲಾಗಿರುವ ನಿರ್ದೇಶನ ಕುರಿತು ಸರ್ಕಾರದ ಪತ್ರದನ್ವಯ ಮಾನ್ಯ ಸರ್ವೋಚ್ಚ ನ್ಯಾಯಾಲಯದ ರಿಟ್ ಅರ್ಜಿ ಸಂಖ್ಯೆ WP ನಂಬರ್ so and so of 2010 ಆದೇಶದ ಖಂಡಿಕೆ 53ರ ನಿರ್ದೇಶನಗಳನ್ನು ಕಟ್ಟುನಿಟ್ಟಾಗಿ ಕ್ರಮ ಕೈಗೊಳ್ಳಲು ಪೊಲೀಸ್ ಇಲಾಖೆಯಿಂದ ಕಚೇರಿಯ ಸುತ್ತೋಲೆಯನ್ನು ಸಮ ಸಂಖ್ಯೆ 7/5/24ರಂದು ಅನ್ವಯ ಎಲ್ಲಾ ಘಟಕ ಅಧಿಕಾರಿಗಳಿಗೆ ಈ ಕುರಿತು ಕ್ರಮ ಕೈಗೊಳ್ಳುವಂತೆ ನಿರ್ದೇಶಿಸಿ ಹೊರಡಿಸಲಾಗಿರುವ ಸುತ್ತೋಲೆಯ ಪ್ರತಿಯನ್ನು ಮಾಹಿತಿಗಾಗಿ ಇದರೊಂದಿಗೆ ಲಭಿಸಿದೆ. So it has been instructed all the
judgment copy ಆದ್ರೂ ಶೇರ್ ಮಾಡಿದೀರಾ? ಅವ್ರಿಗೆ ಏನ್ ಸಿಗ್ಬೇಕು ಮಿಸ್ಟರ್ ರಾವ್?
My lord, we have given along with all the station with the Supreme Court judgment copy.
ಎಲ್ಲಿ ಹೇಳಿದೀರಾ ಅದು? Where it is said that it's enclosed?
But as per the instructions, it has been communicated to me like that.
Not reflected here. Please send it to all of them on their email ID, on their WhatsApp, everything.
Yes.
Everybody should have it.
Yes.
Kannada translation kodi.
Please.
ಎಷ್ಟೋ ಜನಕ್ಕೆ ಇಂಗ್ಲಿಷ್ ಅರ್ಥ ಆಗಲ್ಲ.
Okay.
And these are the people and the on the ground. ಅವ್ರ ಪಾಪ ಕಷ್ಟ ಆಗತ್ತೆ ಆಮೇಲೆ.
Please, my lord, with the Kannada translation copy with the entire Supreme Court and the directions of Supreme Court also.
ನೀವು ಗೈಡ್ಲೈನ್ಸ್ ಮಾಡಿ ಹಿಂಗ್ ಮಾಡ್ಬೇಕು ಅಂತ ಅವ್ರಿಗೆ ಎಕ್ಸ್ಪ್ಲೈನ್ ಮಾಡಿ ಟ್ರೈನಿಂಗ್ ಕೊಡ್ಬೇಕು ಅಂತ ಹೇಳಿರೋದು ಸುಪ್ರೀಂ ಕೋರ್ಟ್.
Please, my lord, we'll imply.
ನೀವು ಒಂದೊಂದಕ್ಕೂ ಒಂದೊಂದ್ ದಿನ ಸುಮ್ನೆ ಅಡ್ಜನ್ ಮಾಡ್ಕೊಂಡು ಹೋಗ್ತಾ ಇದ್ರೆ ವಾಟ್ ಇಸ್ ದಿಸ್ ಮಿಸ್ಟರ್ ರಾವ್?
My lord, we are even the deputy.
It is being said as if it is the judgment of this court. It is not the judgment of this, is the judgment of the Supreme Court which you have to implement.
We will Kannada translations will communicate all the station.
You have to hold training sessions for them is what the Supreme Court has said.
Please.
ಸುಮ್ನೆ ಒಂದು ಸುತ್ತೋಲೆ ಕೊಟ್ಬಿಟ್ಟು ಖಂಡಿಕೆ 53 ಅಂದ್ರೆ ಆಗಲ್ಲ.
The entire directions of the Supreme Court also.
ನಾವು ಐಟಮ್ ನಂಬರ್ so and so dismissed ಅಂತ ಹೇಳ್ದಂಗೆ ಆಗುತ್ತೆ.
We'll submit, my lord.
Please do a proper job out of this.
I will communicate to the concerned department.
Additional Advocate General has filed a memo enclosing two circulars which have been issued. A period of the circulars indicates that a reference to an order passed by this court in the above matter, as also the judgment of the Honorable Apex Court in Shakti Vahini's case has been made. However, there are no particular instructions which have been given to the concerned police officers as to how to deal with the matters as indicated by the Honorable Apex Court in the above judgment. It would firstly be required for the state government to make available copies of the judgment, both in English and in Kannada, to the concerned officers. And secondly, it would be required for the state to have proper training, conduct proper training exercises to sensitize the police officers as regards the directions which have, as regards the detailed direction which have been issued by the Honorable Apex Court in Shakti Vahini's case. Faced with the above situation, Learned Additional Advocate General seeks for and is granted 2 weeks' time to place on record the further progress in implementation of the judgment of the Honorable Apex Court in Shakti Vahini's case. released on 6th August.
Much obliged.
Number 2, for being spoken to, serial number 1, D. Ramesh.
Yes. When so far as the directions issued on the last date, I have written to the DCP, who's the
ಇನ್ನ ಏನೂ ಬಂದಿಲ್ವಾ?
authority, ಬರ್ದಿದೆ. The present incumbent has taken charge last week. Transfers iತ್ತು. They have received. I called them today. They will. I'll place it for lordship. On the very day they have received, may pass it on.
ಅವ್ರಿಗೂ ಒಂದು ಕಾಪಿ.
ಕೊಡ್ತೀನಿ. This is the letter. This is a letter which was returned to the disciplinary authority, the DCP.
Was there any effort made? First you have to show us that. ನೀವು ಸ್ಟೇಟ್ ಡಿಸಿಪ್ಲಿನರಿ ಅಂದ್ರೆ ಮಾಡಿಲ್ಲ ಅಂತಾನೆ ಅರ್ಥ ಆಯ್ತು.
ಅಲ್ಲಲ್ಲ, to initiate action.
Mr. Belliyappa, if your police officers had gone to his place to find out if he is there or not, then we'll reject Mr. Ramesh's petition. The fact that you have said here that disciplinary action is being initiated against that police officer, andre he has filed a false report anta mugitu.
Allala, in the disciplinary proceedings that could be held, there will be the facts which would emerge.
Then that means you are initiating disciplinary proceedings to as a fishing exercise.
No. Proceedings for having not served. That's exactly what I've stated. Your Lordship may kindly see the letter.
The position of this court is not to initiate any disciplinary action against anybody unnecessarily.
Yes.
Please, we don't want that to happen. If somebody has discharged their duties properly, then they should not be made to suffer this. If they have not done it, then definitely you have to take action.
Yes.
So if first you will have to tell us if they have done anything or not, or if we go by this, then he is not done anta mugito.
This is pursuant to your Lordship's order. Previous, kindly see the order dated there. Kindly see the order, your Lordship.
There might have been some hanky-panky and collusion between the petitioners.
So
So
therefore-
statement has been produced today and that necessary action will be taken.
Yes.
That's your submission.
Yes. So,
Might be, so now it is been.
ಅದೇ ತಕೊಳ್ಳಿ ಅಂತ, because on the face of it, there is no
After
effort
nothing.
made by the said inspector. COVID was the only reason. But subsequently he was arrested. Of course.
Yaru.
He was arrested. The A1.
After the charge sheet has been filed, my lord.
The charge sheet was filed, he was arrested.
Yes.
He was arrested. Now the issue is whether to treat him as absconder, was there any effort?
From the records, it noticed that no serious efforts or steps appear to have been taken to trace and secure the accused.
Yes.
And serious allegation of so and so. Under circumstances, it's desirable that a disciplinary proceeding against the police constable concerned is initiated either under the so and so or under any other rules.
So it's in this background, the letter is issued to the DCP to take appropriate action. Now, put that annual to the benefit of the petitioner is the issue. If steps have not been taken to, Lord, he need not be interrogated. He's an accused. His statement need not be recorded to file a report under section 173. So therefore, it is on merits, but not on the ground that he was treated as an absconder, that he was not involved in the investigation. This is not privilege of an institute, money of an institution.
Then
So-
I'll hear you on the merits.
Yes, on the merits of
Merits,
it.
You want to now argue on merits and
Alala,
that's what your submission.
this is the steps that I've taken, that's all.
So now we'll have to hear both of you
Yes,
on
that,
merits.
that-
Both of you are ready.
So that cannot be a ground is my submission.
That is one of them.
One of
Yeah, Other than that, on merits, we'll have to hear both of you.
Yeah.
So both of you are ready.
Would you not-
What has happened, my lords, the order passed by this honorable court is released. Signed and released, my lord.
Yaudu.
This order, my lords, final order.
Final order release ಹೆಂಗಾಗತ್ತೆ being spoken to ಅಂತೀವಲ್ಲ ಆಗಿದ್ಯಾ?
ಆಗಿದೆ. Because my lords,
ರಿಲೀಸ್ ಆದ್ಮೇಲೆ ಬಂದ್ರ
lords, after 2 days, my lords, it was mentioned by Nageshappa, my lords, SPP, regarding saying that I have moved the matter. The lordships has fixed the date on 8th, I think so, my lords. 3rd. Or 3rd, it was not listed, and 4th, it was listed.
The order is already released.
Yes, my lords, so.
Then
That's the only ground, my lord.
order is
No, my lords.
already released ಅಂದ್ರೆ ಇವಾಗ
On
ಏನ್
merit
ಮಾಡಕ್ಕೆ
also, my lords, on merits also, this honorable court has also considered, my lords, because while framing the charge sheet, my lords, the persons who have withdrawn the cash from the account and the name, the person who has opened the account, my lords, he was arraigned as a accused in.
ಅಲ್ಲ, ಇವಾಗ already order release ಅಂದ್ರೆ we don't have the power to review it.
But the very next day, yeah, I think I moved not. No, not afternoon, my lords. After 2 days, my lords, it was moved. I'm sorry. No, that's the only ground.
If it's already released, then we can't do anything. Otherwise, we would have heard both of you on merits and considered it afresh. If it's been released, then we can't do anything.
But this is the only ground on which this is allowed.
But your
Participation-
apprehension that it will become a precedent, that is not there, Allah. Not yet.
ಇಲ್ಲ,
Correct.
it's not. It's not-
Correct
it's
ಆಗಿದೆ
not
ಅಲ್ಲ?
there. But then.
Because that is the apprehension that you had expressed.
Yes, my lords, because Nageshappa, my lords, Nageshappa also expressed that, my lord. That was the apprehension.
ಅದೇನಿಲ್ವಲ್ಲ,
ಅದಿಲ್ಲ.
ಏನ್ ಕರೆಕ್ಷನ್ ಏನ್ ಬೇಕಾಗಿಲ್ಲ ಅದ್ರದ್ದು.
And principles and. So this could be used on facts also, some of them use. So therefore.
If it's been
There's
signed,
no role.
then we don't have power to review.
Yes, 362 is a bar. No, the accused has no role in the investigation unless called upon by the police. As otherwise, it is like saying, "Yeah, give me notice and I will answer." Is not the.
We haven't said that he has a right for that. We have only said that there is no proper investigation which has happened. I think
Yes,
that is what we have
because-
said.
Because that he was not involved in the investigation, that he was not questioned. Believe that.
Rightly, wrongly, we have passed the
Yes,
order ಅಂತ
right,
ಹೇಳ್ಬೋದು
right.
ಅಷ್ಟೇ.
362 is a bar. But I was under the impression that very next day I moved and the lordship instructed them not to.
The criminal petition ಎಲ್ಲ ಬೇಗ ಸೈನ್ ಮಾಡ್ಬೇಕಲ್ಲ ನಾವು. The other ones can stay a little, not this.
Yes, as your lordship rightly remembers, that my submission was that shouldn't be a precedent.
And that we told you, we have not said like that ಅಂತ ಹೇಳಿದ್ವಿ ಅವಾಗ. We also did not check whether it was signed or not.
Not all subsequent orders then becomes a nullity. Now that my letter is also there before the disciplinary authority, and that could be there, but all the subsequent orders. Let's see.
Yeah, disciplinary, you have taken action on the basis of your records.
Yes,
That will continue.
yes, I'll continue, but.
And if you find any collusion between him, then that will be another ground against them.
Yes, yes. But the records would show that the matter itself is disposed on 25th June, and then my letter would refer to the High Court order.
25th June.
Yes, my lord.
And 4/7, when the matter was taken up.
Yes. So if there is a bar.
That is why there's a huge gap. You must have moved on 3/7 and it was taken up on 4/7. So ಅಷ್ಟೊಳಗೆ sign ಆಗಿದೆ.
Well, it's 2/7 he moved and mentioned to me.
2/7 or 3/7, it must
Yes,
have
my
been moved for it to be taken up. 2/7 in the ಇಲ್ಲ.
Very next day I moved. Very next
ಇಲ್ಲಿ ಇಲ್ಲಲ್ಲಪ್ಪ, ಯಾವ್ದು ಆರ್ಡರ್ ಶೀಟ್ ಇಲ್ಲ.
Order sheet ಬಂದಿರೋದು after
4/7.
it was posted.
We would have immediately posted it ಅಲ್ಲ.
ಇಲ್ಲ post ಆಗಿಲ್ಲ, ಅದು 3 ದಿನ.
ನೀವು ಮೆನ್ಷನ್ ಮಾಡಿದ್ರೆ immediately post ಮಾಡಿದ್ದು.
Post ಆಗಿಲ್ಲ. Immediate post ಆಗಿಲ್ಲ. Because very next day I made a submission. So, my lords, when the matter
You
was.
would not have adjourned it by 7 days
No, my lord.
for it to be listed.
Because when it is.
Either you must have moved on 2nd or 3rd, most probably 3rd. For it to
Lord,
be
second
listed.
they moved.
On
My
the
lordship,
4th.
on second, my lords, your lordships also informed me that they have moved the matter.
2nd July and Tuesday, Wednesday, 3rd July, 4th July, it's been listed. 25th was Tuesday of June.
There should be memo on record that would indicate the dates. Illi court officer. because. No, no.
ಅಲ್ಲ ಇದು ಮೆಮೊ ಅಲ್ಲ, ಇದು ಮೆಮೊ ಮೇಲೆ 5-4 ಅಂತ ಬರೆದಿದೆ. It can't be 5-4.
ಏನು ಅಂದ್ರೆ it could be 5-5 then.
5-4 ಅಂದ್ರೆ 5-7 ಗೆ 5-4 ಅಂತ ಬರ್ತದೆ.
5-7.
ಇಲ್ಲ, ಅದೂ ರಾಂಗ್.
ಅದು wrong.
ಅದು ರಾಂಗ್.
4-7
4-7 has been listed. Date 5-4 ಬರ್ದಿದೆ.
Now the concern is only that I have referred to an order passed by your lordship
Yes.
subsequently.
Subsequently, we have passed the order.
Yes.
It won't be a wrong thing.
No, in my letter to the
ಅದೇ ನಿಮ್ ಲೆಟರ್ ನೋಡೋಣ.
disciplinary authority.
Four-7 you mentioned. The order dated 4-7 ಅಂತಾನೆ mention ಮಾಡಿದ್ರು.
Although what I am saying is, the matter is already disposed of by the Sound Court on June itself, and I would make a reference to your lordship's order dated subsequent to that.
Correct. After it was being spoken to ಅಂತ ಲಿಸ್ಟ್ ಮಾಡಿದ್ಮೇಲೆ it has been taken and this order has been passed.
That remains.
There should not be a problem.
That would remain on record. That
It will remain on record. Though it has been disposed of after being spoken to ಅಂತ ಆದ್ಮೇಲೆ
The only thing is 362 is a bar for entertaining.
ಅದಕ್ಕೆ ಸ್ವಲ್ಪ,
Yes.
otherwise we are ready to hear both of you.
Yes.
Leonard, additional, SPP has filed a memo, has placed a letter dated, ಏನಪ್ಪ date
It's there on.
11/7/2024, addressed by the Office of the Advocate General to the Deputy Commissioner of Police. The same is taken on record. It is made clear that in the event of during the inquiry, any culpability of the petitioner being found, the respondents would be at liberty to initiate fresh action against the petitioner.
Much.
Order serial number 2. Dinesh Rao.
The report ಅಲ್ಲಿ
ಕಾಪಿ ಮಾಡ್ತಾರೆ. ಮೆಮೊ ಬರ್ಕೊಡ್ತೀನಿ. ಅಲ್ಲ, ಕಾಪಿ ಮಾಡಿ. ಕಾಪಿನೂ ಬೇಕು ಮೆಮೊ.
A joint report of the Registrar Computers and the Registrar Judicial has been placed on record. It is stated that there's a memo which has been issued by the Registrar Judicial to all officials working in the filing counter to ensure that the enrollment number of the advocate is entered when Wakalatnama is received. The said report is taken on record. There being due compliance with the direction issued, no further orders are required to be passed. The petition stands closed.
Serial number 3 adjourned. Serial number 4. Vishwanath R. Hegde.
This is a matter where in the suit, parties have entered into a compromise. A compromise petition was filed. And your lordships.
Yes, Mr. Rajgopal, have you received instructions?
Keep the body present, he has come to the court.
Where is that compromise petition? OS number 97 ಅಲ್ಲಿ ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದೀರಾ ನೀವು?
Yes, ಅದು ಏನ್ ನ್ಯಾಯ ಸಿಕ್ಕಿಲ್ಲ ಮಾಡಿ.
ಹಾ?
ಅದೇನ್ ನ್ಯಾಯ ಸಿಕ್ಕಿಲ್ಲ.
ಕನ್ನಡ ಬರಲ್ವಾ? ಸರಿ, ತೆಲುಗು ಮಾತಾಡ್ತಾರೆ ಅವರು.
ತೆಲುಗ? ఇది OS 97 of 2009 అని ఉంది కదా, దాంట్లో ఏం సెటిల్మెంట్స్ చేసుకుంటున్నారా మీరు?
Yes, అదేం న్యాయం సిక్కిಲ್ಲ ಮಾಡಿ.
మీ పేరేమి?
నారాయణ.
నారాయణప్ప.
Third response.
నారాయణప్ప is the plaintiff.
ಅಲ್ಲ, second defendant.
Another Narayanappa is
ಹೌದು.
there.
Plaintiff is the petitioner in this writ petition. This suit OS number 97 of 2009 was filed based on a will executed by the original grantee, Mr. Pujappa, under
Now,
whom
where
the-
is his signature?
their
Friend
photos are
number
also there, my lord.
Narayanappa.
On page 4, photographs are also there.
ಇದು ತೋರಿಸಿ ಅವ್ರಿಗೆ. ಇದು చూడండి, ఇది మీ సిగ్నేచరా? సరిగా చెప్పండా? ಫೋಟೋನು ತೋರಿಸಿ ಅವ್ರಿಗೆ.
ಸೈನ್ ಮಾಡ್ತೀಯಪ್ಪ ನೀನು? ಸೈನ್ ಹೆಬ್ಬೆಟ್ಟ? ಸೈನ್ ಹಾಕ್ತಾರಾ? ಯಾರು ಸೈನ್ ಇದು? ಎಂ ನಾರಾಯಣಪ್ಪ. ನಾರಾಯಣಪ್ಪ ಅಲ್ವಾ? ಥರ್ಡ್ ರೆಸ್ಪಾನ್ಸ್.
ಎನ್ ನಾರಾಯಣಪ್ಪ plaintiff. ಇವರು D2 ನಾರಾಯಣಪ್ಪ.
ಆರೆಂಜ್ ಫಾಂಟ್.
D2 ನಾರಾಯಣಪ್ಪ ಅಂತಿದೆ ಸರ್. ಕಾಂಪ್ರಮೈಸ್ ಪಿಟಿಷನ್ ಇದೆ. ಚೆಕ್
ಅಲ್ಲ, ಇಲ್ಲಿ ನೋಡುತ್ತಾ
ಫೋಟೋಗ್ರಾಫ್ ಇದೆ, ಅದನ್ನು ತೋರಿಸಿ. ಕಾಂಪ್ರಮೈಸ್ ಪಿಟಿಷನ್ ಎಂಡಿಗೆ ಫಸ್ಟ್ ಡಾಕ್ಯುಮೆಂಟ್ 4th ಪೇಜ್. ಅದೇ
ನಿಂದು ಫೋಟೋ ಯಾರಪ್ಪ ಇದರಲ್ಲಿ? ಅದು ಇದು ಐಡೆಂಟಿಫೈಂಗ್ ಸೆಕೆಂಡ್ ಫೋಟೋಗ್ರಾಫ್.
ಸಿಗ್ನೇಚರ್ ಕೇಳಿ.
ಇದು ಸೈನ್ ಇದೆಯಲ್ಲ, ಎಲ್ಲಿ ಸೈನ್ ಇದೆ ನಿಂದಲ್ಲಿ? ಇಲ್ಲಿ ಎಲ್ಲಿ ಸೈನ್ ಮಾಡಿದ್ಯೋ?
మీదేనా హస్తాక్షరము?
ಇದನ್ನೇನು? ಹಾ, ಸೈನ್ ಮಾಡ್ತೀಯಾ? ಹೆಬ್ಬೆಟ್ ಹಾಕ್ತೀಯಾ? ಸೈನ್ ಮಾಡ್ತೀಯಾ? ಯಾವ ಭಾಷೆಲಿ ಮಾಡ್ತೀಯಾ ಸೈನ್? ಭಾಷೆ ತೆಲುಗಲ್ಲಿ ಮಾಡ್ತೀಯಾ? ಕನ್ನಡದಲ್ಲಿ ಮಾಡಿದ್ದಾನೆ.
It is a signature. So what do you want us to do if it's...
No, I am not coming in the way. Compromise has taken place, there's no problem about it. But that compromise has got any effect on these two writ petitions, that's all.
Compromises?
Compromise has taken place. This is the way what's called, this is the lamp coming under the provisions of PDCL Act.
As he signed it and as he appeared before the court and
So
signed it.
Lordship may kindly see that whether land
Please
granted.
answer this first question, then we'll come to the bindingness and those things later.
No, we don't, so for the compromise is concerned, I don't have any problem. I am not there, but local advocate were there, no, I have, but what's called, he has, I'm just seeing him now. And this is all right, I know, I'm not a part, I'm not an advocate for this now. But admit that his photograph and also the signature.
Mr. Rajgopal, we are not concerned whether you are an advocate there or not. You are representing him here. So for all we care, you are representing him everywhere.
But
And don't try to draw that distinction.
No,
That
Lordship
will be
may-
testing our patience on that.
No, Lordship
You
may-
have appeared, whether you have appeared or not, we are not concerned. Your client has signed it is what we are asking. We are not asking whether you have
This
signed. it.
compromise, he admits his photograph, he also admits the signature. I don't know what's called, I can.
Why did he sign it there?
Huh?
Why did he sign it there?
ಏತಕ್ಕೆ ಸೈನ್ ಮಾಡಿದೆಪ್ಪ ನೀನು? ಈ ಕಡೆಪ್ಪ, ಮುಂದೆ ಬಾ, ಇನ್ನು ಸ್ವಲ್ಪ. ತೆಲುಗು ಗೊತ್ತಿಲ್ಲ.
We'll do one thing, we'll initiate proceedings, let him explain it there. This kind of conduct cannot be tolerated. You enter into a compromise there and say, no, that compromise is not binding on this matter.
No, I not said that. I know that the document is here, he is also present, he identified his what's called photo, he identifies signature, I have no voice at all. The compromise petition, they got an approval and it was called, it is disposed of.
Yes.
I don't deny it, first of all.
So if there's a compromise done, that will be binding on him. He cannot take any other stand contrary to it. Kodiel. Petitioner is before this court seeking for the following reliefs. The petitioner claims to be the owner of the land in survey number 141, new number 141/P3, measuring 6 acres, situated in Eralekkenalli village, Somenalli Obli, Gudibanda Taluk, and acquired the same under a registered will dated 6/11/91. Respondent number 3 and 4, claiming to be members of the scheduled caste and grandchildren of Pujappa, who had executed the will in favor of the petitioner, had alleged that the granted land had been alienated under a will, and as such proceedings were initiated under section 4 of the PTCL Act 1978, seeking for restoration plan. The petitioner had also filed a suit in OS number 97 of 2009 before the Civil Judge Junior Division, JMFC Gudibanda, for declaration that he is the owner of the land in question and for a permanent injunction. In the said suit, the petitioners and respondent number 3 and 4 entered into a compromise on
16/3/2024.
16/3/2024.
Respondents 3 and 4 and their family members.
Along with the family members of respondent number 3 and 4. And by virtue of the said compromise, a decree was directed to be drawn up, confirming that the petitioner is the owner of the land subject matter of the said suit.
Not
this
2.5 acres for the petitioner and 3.5 acres for the respondents there and their family.
But you were declared for only that, Alva. Decree is only for.
Compromise is for that.
Compromise is, sorry, in terms of the compromise, it was agreed that the petitioner would be entitled 2 acres,
20 guntas.
20 guntas, and the respondents 3 and 4 along with their family members would be entitled to 3 acres, 20 guntas in the aforesaid survey number. The submission of the counsel for the petitioner is that in terms of said settlement, parties have acted upon, and the said settlement would be binding on the parties, and as such, the proceedings which have been initiated under section 4 of the PTCL Act cannot be continued, could not have been continued, and as such, the order passed by the Assistant Commissioner in the said proceedings on 25/2/2019, despite the above compromise having brought to the notice of the. No, it was not brought to notice.
No. It is only recently, my lord.
The said order would not survive in view of the compromise which has been entered into. Learned counsel for the respondent 3 and 4 would submit that the suit is a civil proceeding as regard the ownership, and the present proceedings before the Assistant Commissioner is under section 4 of the PTCL Act, seeking for resumption of the land on the basis of violation of the term of grant. And as such, his submission is that the compromise which has been entered into in the suit in OS number 97 of 2009 would have no bearing insofar as the order passed by the Assistant Commissioner is concerned. Heard Shri Vishnu Tegade, learned counsel for the petitioner, Shri T.K. Rajgopal, learned counsel for respondent number 3 and 4. Though the submission of the learned counsel for respondent number 3 and 4 is that the compromise in a suit would not have any bearing on the proceedings under section 4 of the PTCL Act. And the contention of the learned counsel for us is that the compromise in a suit would not be having any bearing on section 4 and the proceedings filed under section 4. I am unable to accept the said submission. The suit was one for declaration title, and in the said suit, the parties have arrived at a settlement whereunder the petitioner would be entitled to 2 acre 20 guntas and the respondent would be entitled to 3 acres 20 guntas. Having entered into such a compromise before a court of law, it would not be available for the respondents to now contend before this court that the compromise in the suit would have no bearing insofar as the proceedings under Section 4 of the PTCL Act. Such a contention, in my considered opinion, would not only be an abuse of the process of court, but would also be a fraudulent contention taken. Though this court could initiate action against the respondents in respect of the above, taking into consideration that the respondents belong to a marginal class of society and may not have society, I refrain from doing so. The compromise which has been entered into in OS number 97 of 2009 would equally apply to the proceedings in the Section 4 and or any other proceedings under the PTCL Act, inasmuch as a decree, a compromise entered into before a court upon legal advice is binding on the parties, and no party can resile from any obligation undertaken under a compromise petition before a court, in furtherance of which a decree has been drawn up. In this particular case, the petitioner being entitled to 2 acres 20 guntas, the respondents being entitled to 3 acres 20 guntas, the respondents have also derived a benefit under the compromise, and therefore it is not available for them to resign from such a compromise which has been entered into. In that view of the matter, I pass the following order. Writ petition is allowed, a certiorari is issued. The order dated 6/8/2014 in so and so, passed by second respondent and Annexure B, and the order dated 25/2/2019, passed by the first respondent and Annexure C, is hereby quashed.
Para 4 of the compromise, parties have agreed to withdraw all the proceedings before the revenue authorities.
The a perusal of the compromise would also indicate that in terms of para 4 of the compromise, the parties have agreed to withdraw all the proceedings filed between themselves, which would include proceedings under the PTCL Act. Having entered into such an agreement and a compromise decree having been drawn up, it would not now lie for the respondents to resile from such a contention and continue to prosecute the matter.
Right.
Passed over matters. List number 1, serial number 8.
Once application.
Receives.
One number 3 and 6 and 8.
Yeah, who is expert? Respond number 5. You accept notice for respond number 5?
I appear for respondent number 3 and 6 and 8 to see.
You respond number 5 legal airs, you will accept notice? The notice hogbeka.
My lord, respond number 5, no one has appeared earlier occasion, so the notice has to.
Will they accept anta adike kelta iradu? You don't accept. During pendency of the above matter, respond number 5 is expired. As such, IA 3,
Yes.
1, 2.
Yes.
And 3, okay.
3, 2. And
IA number 1 of 24, 2 of 24. and 3 of 24.
4 of 24 in.
This way, 4 of there is a delay. They're not appearing, then we can't press that. Nobody is appeared.
1 of 24, you are not pressing.
My lord, 1 of 24, it is allowed, my lord. That's insofar as the deputy first petitioner is died, your lordship. Therefore, I made an application for condone the delay.
1 of 24, 1 nimsha irri. 1 of 24 is for petition number 1.
Yes, your lordship.
So 1 has been allowed.
Allowed, yes, your lordship.
2 is for
2 is for to bring a loss of R5.
IA 2, 3 and 4
4, yes, sir.
of 2024 have been filed. Issue notice on IA 2, 3 and 4 of 2025 on the person named in IA 2 of 2024, returnable by 20th September.
21, P. Shivkumar.
Yes, madam.
I appear for petitioners, my lords.
Yes.
Kindly grant one short accommodation, my lords. It will be posted to Monday.
For what?
Will comply the office objections, my lords.
The council submission is rejected. Learned counsel for the petitioner seeks bond is granted. Office of 1 week's time to comply with office objection released on 26th.
Serial number 54.
This matter.
File ಆಯ್ತಾ?
Yes, your lordship.
ಏನಕ್ಕೆ ಡಿಸ್ಮಿಸ್ ಆಗಿದ್ದು?
Lordship, respondent number 4 and 5 ಗೆ ಟೈಮ್ ಕೊಟ್ಟಿದ್ರು. ಕಂಡೀಷನಲ್ ಆರ್ಡರ್ ಆಗಿತ್ತು. ನೋಟಿಸ್ ತಗೊಳ್ಳಿಲ್ಲ. ಸ್ಟೆಪ್ ಪ್ರೊಸೆಸ್ ಫೀಸ್ ಅಂಡ್ ಕವರ್ ಅಕ್ನಾಲಜ್ಮೆಂಟ್ ಕಾಪಿ ಕೊಡ್ಲಿಲ್ಲ ಅದಕ್ಕೋಸ್ಕರ.
ನೀವು ಪೇಮೆಂಟ್ ಮಾಡಿಲ್ವಾ? ಇವಾಗ ಮಾಡಿದೀರಾ?
Today morning itself I am filed.
By way of order at 31/5/2024, a preemptory order had been passed stating that the petition against respondent number 4 and 5 would be dismissed, would stand dismissed if process fee was not paid within 2 days. The petitioner did not make payment of the process fee within the 2 days, but paid on
Today itself morning.
ಏನು ಒಂದ್ 2-3 ದಿನ ಡಿಲೇ ಅಂದ್ರೆ ಒಪ್ಕೊಳ್ಳೋಣ. 1 ತಿಂಗಳು ಡಿಲೇ ಅಂದ್ರೆ
20 days.
ಏನ್ 20 days? ಲೆಕ್ಕ ಮಾಡೋಣ.
1 month.
ಲೆಕ್ಕ ಮಾಡೋಣ. 45 days has been filed, paid today. Though the period of delay mentioned in section 5 application, that is IA 1 of 2024, is not correct, accepting the reasons stated therein, the delay in making payment of the process fee is condoned, subject to payment of cost of ₹1,000 to the Advocates Clerks Benevolent Fund. Accepting the reasons stated in support of IA 2 of 2024, the order dated 31/5/2024 is recalled. The process fee paid now is taken on record and registry is directed to issue notice to respondent number 4 and 5. The dismissal of the petition insofar as respondent number 4 and 5 stands recalled.
Much.
Returnable by 27 September.
Much.
Serial number 56.
Kindly pass. Kindly pass. Senior counsel. Yes.
ಇದು ಎರಡೇ ಇರೋದು 56 62.
Senior
ಏನ್
is
pass
held up
over
in
any.
court on 19. Senior is held up.
Before we call it again, they better be here, otherwise we'll adjourn.
Otherwise, it may be posted on Monday.
Not Monday. Yes, next.
Serial number 62. Chandrasekhar C.
Mr. Chandrasekhar. None appears for the petitioner, though called thrice, twice in the morning session, once in the afternoon session. If none were to appear for the petition on the next date of hearing, petition would be liable to dismiss for non-prosecution. Relist on 9th August. Yes. Sorry, Ribbon.
Serial number 56.
Yes, Mr. Shankar. Petitioner ಎಲ್ಲೋದ್ರು? ಕರ್ಕೊಂಡು ಬರಕ್ ಹೋದ್ರ? This is the only matter left now. Any issue of delay or anything in this?
Not this is a case where sale permission is challenged after lapse of 12 years.
Sale permission, but sale deed has been executed?
2 sale deeds have been executed. In both the sale deeds, they refer to the sale permission and sell the property in the year 2004. Subsequently, there are various civil proceedings between the parties. Subsequently, they approached the SC/ST Commission and lodge a complaint against me for creation of
Creation,
creation of the sale deed and trying to put up construction in the property.
creation of sale deed is different. Creation of the permission sale deed.
ಸೇಲ್ ಡೀಡ್ ಅಲ್ಲಿ ಸೇಲ್ ಡೀಡ್ ಕೇಳಿ ಆಮೇಲೆ ಅಟ್ರಾಸಿಟೀಸ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ, ಪ್ರಾಪರ್ಟಿನಲ್ಲಿ ಬಂದು ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಶುರು ಮಾಡ್ಕೊಂತ ಇದ್ದಾರೆ ಅಂತ ಹೇಳಿ ಅಲ್ಲಿ SC/ST ಕಮಿಷನ್. I challenge the said proceedings before this honorable court. This honorable court quashed the proceedings because the SC/ST commission had granted interim order as if it is a civil court directing me not to put up any construction on the property. That was quashed by this honorable court. Subsequently, one of the other family members files a suit for partition, that is the fourth petitioner, files a suit for partition against me, challenging the very same sale deed. There is no dispute in so far as sale permission is concerned. It is never their case sale permission was not granted. That suit, my lord, has been dismissed, against which, my lord, an appeal is pending before this court. And all these proceedings are pending. They approach the deputy commissioner, make an application and say, in the year 2003, when we make an application, those thumb impression signatures are not ours. Therefore, no sale permission is done. Therefore, the deputy commissioner, my lord, records their statement without issuing notice to me, cancels the sale permission. That was challenged by me before this honorable court. This honorable court, my lord, in a writ petition, directed, my lord, the government, because it is the government who has granted sale permission, deputy commissioner cannot cancel it. Therefore, it refers to the principal secretary, my lord, for holding an inquiry and seeing whether that sale permission is actually granted as per the records. The report has come, my lord, saying that it is a valid sale permission. That particular report of the government is now challenged in the present writ petition.
Kindly pass or adjourn. Senior is held up in next court.
And the request of the petitioner released on 2nd August. Records idea, madam? Released on 9th August, the learned AG
Last date
is.
of hearing, there was a direction issued by this honorable court to secure the records.
Then, released on 9th August, learned AG has submitted that she says to secure the records. Records to be secured by then.
Interim order may kindly be.
Interim order earlier
Difficulty,
granted.
my lord. Status quo is granted. They don't want to conduct.
Status quo.
Status.
What is status quo? ಯಾವತ್ತು status quo ಕೊಟ್ಟಿರೋದು? When was the order passed?
Lordships may kindly refer to the order dated 4/10/2023. 4/10/2023.
4/10/23 na. There's an order, reasoned order passed. We'll have to extend it until interim order earlier granted is extended till next date.
Great.